Good afternoon, ladies and gentlemen. This meeting will come to order. This is the regular meeting of the Land Use and Transportation Committee. I'm Supervisor Malia Cohen. I'm chair of this committee, and to my right is Supervisor Scott Wiener, and to my left is Supervisor Katie Tang, who is going to be sitting in on behalf of Supervisor Jane Kim. Our clerk is Miss Andrea Osbury, and I also would like to recognize Jim Smith and Jesse Larson, who will be providing SF Gov TV broadcasts of this committee on Channel 26. Madam Clerk, do you have any announcements today?
Yes, please silence all electronic devices. Completed speaker cards and copies of any documents to be included as part of the file should be submitted to the clerk. Items acted upon today may appear in the May 12, 2015 Board of Supervisors agenda unless otherwise stated.
Thank you very much, Madam Clerk. Could you please call items number 1 and 2 together?
Yes, item number 1 is an ordinance amending the health code to revise regulation of massage practitioners, establishments, and associated fees. And item number 2 is the ordinance amending the planning code requirements of massage establishments.
All right, thank you. Supervisor Tang is the author of these 2 items. She's here with us today. Supervisor Tang, do you have any remarks?
I do. Thank you very much. So I want to thank everyone who came out for this item, or for items 1 and 2. So just by way of background, today I have legislation that proposes amendments to both the health code and the planning code. So without going into incredible detail about each of the amendments that have been made, we did submit substitute legislation last Tuesday, so all of those amendments are part of the public record. But in terms of the changes that we're making, I wanted to share with the committee just a very brief high-level overview of why we're doing this and why we're here today. Back in 2003, and prior to that, actually, the jurisdiction over enforcement and regulation of massage establishments in San Francisco was actually under the San Francisco Police Department. In 2003, the jurisdiction over that transferred to our San Francisco Department of Public Health because there was some concern that we were criminalizing the industry, and so turning over to the Department of Public Health allowed for us to have a much more, how should I say, trying to decriminalize the industry. So then in 2006, San Francisco actually established a permitting process through our Department of Public Health, and back then we had our former District 4 Supervisor, Fiona Ma, who actually, through the Board of Supervisors, required a conditional use permit for all massage establishments to open. So again, this was back in 2006. Then in 2009, there was state law that was passed, which was SB 731. And it created a new entity, which was the California Massage Therapy Council. For short, that is CAMTC, with the regulatory authority over the certification of massage practitioners. There were also new limitations on the authority of cities, though, to enact or enforce certain regulations applicable to CAMTC certified individuals and establishments employing only CAMTC certified therapists. Now, I think that when CAMTC was created, it was really for a good reason. They're not all cities in California actually have a permitting process like we do here in San Francisco. And so especially for those jurisdictions that don't, it created a standardized process throughout the state of California. However, one hardship for cities like San Francisco was that we had our own permitting process, our own system in place. And so we had essentially dual systems, and so we had some establishments that were certified through CAMTC and received an exemption through that entity, and then we also had another set that were certified through San Francisco DPH. And then in the process, we actually found that many were left out of either system, and so there are actually establishments and businesses out there that are not certified, whether through CAMTC or SFDPH. So in 2013, some legislation was passed by the city to actually give our city departments some more tools to work with for better enforcement. And then in 2014, our governor actually signed into law AB 1147, which after hearing concerns from many cities throughout California, not just San Francisco, the state realized that it was really important to return local land use and regulatory controls back to local government to regulate massage establishments. So that is why we're here today. In 2015, that is why I have proposed amendments to our health code and planning code to codify some of the changes that were made through AB 1147. So just in short, for the health code provision, I'll just go over some highlights of what we're trying to do. For the health code, we are removing the exemption of DPH business permits for establishments employing all CAMTC therapists. So now if you are employing all CAMTC therapists, we're going to require that you do obtain a DPH business permit. And the reason for this is that, again, as I mentioned earlier, there are many businesses that are not in either system, and we need to be able to capture all of that. Secondly, it clarifies who is exempt from DPH business permits modeled after San Mateo County. We are thirdly requiring culturally and multilingual outreach and education. And lastly, the major point is that the changes are actually based on input from many of the massage therapists and sex worker stakeholders that we had engaged with. So for example, the permits and certificates are not required to be displayed publicly. However, they will be asked to be made available upon investigation by a DPH inspector, as is required under state law. We are removing the provision where the potential for denial of a permit is only if you are only if you are convicted with certain crimes, not if you are charged with them. And we are changing requirements to make them in line with states, such as with hours of education, attire, and human trafficking posting requirements. In terms of the planning code changes, we are removing the exemption of the conditional use authorization for establishments employing all CAMTC therapists. I know I've heard from many businesses that this is a very burdensome, costly process. I would just say that this is a requirement that was in place since 2006. As we will hear from our former supervisor of District 4, Fiona Ma, this was in place, and there are roughly 100 establishments that have actually gone through this conditional use permit process already, not to mention that many other types of businesses, not just massage, have to go through the CU process. Secondly, we are adding, after hearing many concerns from people, we are adding an exemption from sole practitioners. So sole practitioners, even those who, up to 4 of which can share space together, as long as they have independent businesses, will be exempt from the CU process. We are also, per the suggestion of the stakeholders we work with, we are barring the opening of massage establishments in the location where a massage establishment was shut down for a 3-year period. And lastly, we are adding a legitimization program for currently operating establishments that did not receive proper permits. So that is in a nutshell some of the high-level changes that we're making. Deanna Keyson from my office has worked really hard on this legislation, worked with many, many stakeholders on this, answering lots of questions. And so I'm actually going to ask her to come up and present the details of the amnesty or the legitimization program so that everyone can understand just how flexible we are trying to be so that we are not trying to shut down existing businesses, even if they did not obtain proper permits. We want to make sure that everyone is on the same page moving forward. And so with that, I'll turn it over to Deanna.
Thank you, Supervisor Tang. And SFGov TV, if we can put up the projector. So after we initially heard from massage stakeholders, we quickly realized that there were massage establishments that did not get proper authorization, land use authorizations, for a variety of reasons. Either they were confused by the regulatory process because of this dual-tiered process that came down from the state, or they thought they were automatically qualified for the exemption, so they didn't apply for the permit, or for a variety of reasons didn't get the valid authorization. And our intent from the very beginning was not to shut down any currently operating establishments. We really wanted to get everybody on the same page. So codified in file 141303 in section 177, we explicitly state the intent to establish a time-limited program wherein existing massage establishments that have operated without the benefit of required permits may seek those permits, and while they're seeking those permits, will continue to be in operation. The legitimization program considers these establishments legal non-conforming uses or permitted conditional use as long as they meet the following requirements. It was operating or functioning in that location as of January 19, 2015, and that date is significant because that's when our interim controls came into play that required CUs. It obtained a business license from the city prior to January 19th. All employees obtain valid certifications from CAMTC or valid permits from DPH prior to January 19th. There are no open police department, planning department, or health department enforcement cases against the establishment, and the massage establishment applies for a permit from DPH within 90 days of the effective date. And this is only the application. They don't have to get approval. They just have to apply for that DPH permit, which is in conformity with the health code changes. As soon as possible after the effective date of this ordinance, we will make sure that Planning Department and DPH themselves will post notice of this legitimization program. The Department of Public Health has stated before that they're going to be doing active outreach on this legislation so that massage establishments know the new requirements. We'll even post a notice clearly explaining the variety and myriad zoning, underlining zoning ordinances for many districts throughout San Francisco that zone massage in different ways. So we'll honor that and let massage establishments know what their underlying zoning is. The determination of applicability starts when DPH gets the application for the permit. They'll refer it to Planning Department, who will be the department in charge of determining if the establishment meets all of these requirements for the program. We've also noted that if they do intend to limit or intend to intensify or expand, they will have to follow the standard processes of any CU authorized business in terms of altering or expanding. And we've placed an 18-month sunset on the program so that we will have a reasonable time frame to get everybody under the same standard. And so that's the description of our legitimization program. As Supervisor Tang mentioned, we've worked very, very hard on this to make sure that we encompass all establishments in San Francisco and ensure that they can continue to operate as we regulate and create a uniform regulation standard for massage establishments. So that was one of our highest priorities while speaking with the massage stakeholders and in developing our legislation. So.
Thank you very much, Deanna.
Thank you.
And I know colleagues have some questions, but I'll just conclude by saying that not only is the conditional use permitting process really a tool for neighborhood notification, and it is a tool that we have been using in our city for as long as I can remember for many, many industries, not just massage. There is this concern that in some of our massage establishments, unfortunately, there has been some illegal activity happening. And I know that many have asked how will these changes actually address issues such as human labor, sex trafficking, right? And we are trying to give our various city departments the tools that they need so that they can more effectively go into some of these establishments and really see if there are problems that exist. As I mentioned earlier as well, there are quite a few massage establishments that are actually not part of any system, not part of CAMTC, not part of DPH. And we really need to, through this process, be able to capture where these locations are so that we can actually understand what is going on inside. I will cite that according to our California Attorney General, California is actually one of our nation's top 4 destination states for trafficking human beings. So from around 2010 to 2012, California's 9 regional human trafficking task forces, including San Francisco, identified 1,277 victims and initiated over 2,500 investigations and arrested almost 2,000 individuals, and 72% of the rescued victims were from the United States. So there is a real issue out there, and we realize that it's a larger one than San Francisco alone can tackle, but I think that we need to do everything we can to give our city departments, to the best of our abilities, ways to address this. Not just legislatively, but also through other department actions. So I know that we will have a speaker here from DPH, and she will let you know that we're also trying to figure out ways that we can provide better outreach, more culturally competent and sensitive ways of reaching out to potential victims in some of our massage establishments. So with that then, I'm happy to answer any questions from colleagues. I see some names on the roster. Supervisor Wiener.
Supervisor Wiener.
Thank you to the chair. Thank you, Madam Chair, and thank you, Supervisor Tang, for bringing this forward. This is one of those very challenging pieces of legislation because on the one hand, we have an industry with many very legitimate operators who provide a very valuable service and are employing people and are playing by the rules and doing absolutely nothing wrong. On the other hand, you have establishments that are doing anything but playing by the rules and that are abusing people, where you have just really horrible examples of human trafficking, basically in some extreme instances even effectively sex slaves. And it's just a really terrible situation. So it's challenging to strike that balance where you have these legitimate establishments and you have these highly abusive establishments. And I think it's important for people in the industry who I know have raised some real concerns about overregulation and sweeping in the good actors with the bad actors, that there have been a lot of regulations on the books for a long time. So this is not writing on a blank slate. And I think it is important to make sure that we have good land use controls in place so that we have the tools that we need to deal with these very abusive actors. It's also important to make sure that we are doing what we can to make it easy for legitimate businesses to start and to thrive and to be able to grow, and that we're not stigmatizing an entire industry based on the actions of some bad actors. And so first of all, I want to thank Supervisor Tang and her office for really listening and taking feedback. I know that Supervisor Tang's office had a number of meetings with stakeholders and made amendments. Supervisor Tang has been very receptive to feedback from me and from my office, particularly in making the amendment to expand the exemption from the conditional use, not just extended to solo practitioners, but up to 4 solo practitioners who are co-locating, because we know that there are many situations where massage therapists will share office space and each have a room in a common office. And so I appreciate that exemption. I think that will help a lot of people. I do have just a few issues that I wanted to raise, and I think some of these would, if they were to happen, would need to be trailing legislation, because I don't want to trigger a re-referral to the Planning Commission. And I know Supervisor Tang is aware of all of these, but I just want to raise these now, and I may have questions for staff during the presentations. One is, when you have a legitimate existing massage therapy business that needs to move, let's say they move down the block because they need more space, or they're, as often as all too often happening today, their rent gets doubled, and so they have to find new office space due to this explosive real estate environment, and they're just moving. Is there a way to make it, and they don't have any violations, they've had a clean record, is there a way to not force them to go through the conditional use process simply because they're an existing business that is changing locations? Another issue is that the industry has raised the issue that because they are being shifted from the category of service, health to massage establishment, they're somehow being removed from the general healthcare field. Now, there is a finding at the beginning of the legislation that I think makes it clear that massage has many health benefits, but is there a possibility of changing even the name of the use from instead of calling it massage establishment, calling it service, health, massage, or something like that, where we're at least acknowledging that we're not trying to stigmatize the entire industry, and there are significant health benefits to massage. And then finally, there's an issue that I believe this is not related to Supervisor Tang's legislation, but was actually, I think, instituted by legislation from then Supervisor Carmen Chu. And that has to do with massage therapists who are co-located with either a chiropractor or an acupuncturist or some other health professional. I think right now, under the legislation proposed by Supervisor Tang, as I noted, up to 4 solo practitioner massage therapists can co-locate without going through a conditional use. But if a single massage therapist co-locates with a single chiropractor, for example, they all have to go through a conditional use together, and that creates sort of an odd anomaly. I know that Supervisor Carmen Chu, at the time had sponsored the legislation because there were abuses where an acupuncturist or a chiropractor would open with a bunch of massage therapists, and then all of a sudden the acupuncturist would be gone and it would be a pure massage establishment. But is there a way to extend the up to 4 solo massage therapists co-locating to allow them to co-locate with, say, a chiropractor or an acupuncturist without having to go through the conditional use process? Because we know that more and more we do see these co-locations among various kinds of health professionals where they refer to each other and they work in the same space, but they're not working for each other. I think that that may also need to be trailing legislation. But those are the issues I wanted to raise today and just have it out there as part of the conversation. And I look forward to the dialogue today.
Great, thank you very much. Before we go any further and we go on to public comment, first I want to call up the Dr. Emily Morase from the Commission on the Status of Women to make a brief remarks, and then I'm also going to call up a representative from the Department of Public Health to also speak. Is the Small Business Commission speaking?
I have a list here.
Oh, can I? Emily, please.
Good afternoon, Committee Chair Cohen, Supervisor Wiener, Supervisor Tang. I'm Dr. Emily Murase, Executive Director of the San Francisco Department on the Status of Women. Our department, with the leadership of Women's Policy Director Manoush Kandel, has been staffing the Mayor's Task Force on Anti-Human Trafficking since its inception in March of 2013. And since the beginning, the task force has had an illicit massage parlor committee to examine forced prostitution and human trafficking that goes on illegally in some of San Francisco's massage parlors. The committee has been closely engaged in the development of these amendments, and I personally participated in a nighttime inspection of several massage parlors suspected of human trafficking. These are conducted under the leadership of Ed Walsh at the Department of Public Health in partnership with inspectors from the police department under the leadership of Sergeant Tony Flores, who I know is here, building inspectors and fire inspectors. One of the businesses was operating without a license. Another business shows signs of doubling as housing for employees. And the women I saw were mostly non-English speakers and very scared. Supervisor Tang's legislation ensures that these massage parlors can no longer serve as fronts for forced prostitution and human trafficking, and we are very proud to have worked very closely with her and her aide, Diana Kizan, to craft a proposal that accounts for the needs of victims who, for obvious reasons, cannot be here in this room to stand before you. I urge you to support these important changes to eradicate human trafficking from our massage establishments in San Francisco. You'll also hear more from one of our commissioners, Julie Su, who's here to talk about what the commission has done in support of this legislation. And I'm going to turn it over to Women's Policy Director Manoush Kandel to present briefly on additional information on this topic.
So just to add to what Dr. Morase has said, while it's difficult to obtain accurate data on the prevalence of human trafficking in San Francisco, our inspectors at the Department of Public Health have estimated that in about 50% of the establishments that they inspect, there is illicit activity going on, and that 25% of the women that they have observed show signs of human trafficking. And an episode of that aired on MSNBC this fall showed live video footage that they obtained when they accompanied one of these Department of Public Health inspections, where it was very clear that there were maybe half a dozen women living in a room in one of these establishments. When they were asked whether they had their identification, their passports, they did not have access to them. They claimed that the person running the establishment was keeping them for safekeeping. But these are really red flags for human trafficking that were very visible on this. Polaris, which runs the National Resource Center on Human Trafficking, is launching a national initiative to look at trafficking that's happening in massage establishments, and they find that what they call commercial front brothels, which are include places masquerading as massage establishments, are in the top 3 venues for sex trafficking in the United States. And they were very excited to hear about the work that's happening in San Francisco, including this ordinance, because it's really important to be doing what we can at the local level to address human trafficking. And the ordinances here are addressing the connection between human trafficking that might be happening in these massage establishments in some really important ways. So persons convicted of human trafficking will be prohibited from operating massage establishments, and massage establishments that have been closed down because of violations will not be able to reopen in the new place. And that we're really excited about some of the innovative ways that the ordinance is trying to get information and education to people who might potentially be trafficked in these establishments. So now everybody applying for a permit will get education materials in their language that tells them about their labor rights and trafficking resources. The anti-trafficking poster that's required under state law, and our office helped create the one in San Francisco, will be clearly required to be posted in these establishments. And as Supervisor Tang mentioned, prioritizing the use of bilingual, bicultural health outreach workers is really innovative, a best practice, and something that is flagged in the legislation. And again, I want to thank Supervisor Tang, who worked really hard with our sex worker and trafficking committee to get input from that particular group of stakeholders, which isn't always heard from, and amended the legislation to create more safety so people wouldn't have to display their permits publicly, which might lead to stalking. So we thank her for that, taking that input.
Thank you very much.
Thank you. Through the chair, before I call up the various departments, I just wanted to say that, we did not do this alone. There were many, many departments that helped us on this effort. And so I do want to thank the department and the Commission on the Status of Women. Of course, SFDPH, they again are trying to do everything they can ever since inheriting the enforcement and jurisdiction over massage establishments. I do want to thank our planning department, Small Business Commission, and of course our San Francisco Police Department, who is still working in concert with all of us. I neglected to mention earlier that this legislation actually went before various commissions, including this one, such as the Health Commission. At the Health Commission level, they made some recommendations really to make sure that we address the legitimate therapists and business owners and acknowledge the benefits of massage therapy. And so we did amend our legislation to include that language in there. We also one before the Planning Commission that made certain recommendations, which we have tried to incorporate into our legislation. And we appeared before the Small Business Commission 3 times already prior to this hearing. We do understand that there may be some disagreements, which is absolutely fine. But I just wanted to share that we did go before all these various commissions. So I want to thank Dr. Marase and Manoush Kendall. And next, I'm actually going to call up our Department of Public Health, Cindy Comerford, who's worked pretty much every day alongside us on this legislation.
Okay. Good afternoon, supervisors. Could I get the presentation on the screen, please?
SFGov TV.
Okay. So my name is Cindy Comerford, and I work in the Environmental Health Branch, managing planning and policy. And as many of you guys know, the Environmental Health Branch has 14 different regulatory programs. Some of our environmental health regulations include making sure that hotels are held to certain standards of cleanliness. We regulate taxi cabs to protect the public. We regulate food and restaurants to protect the public from foodborne illness. And we are also tasked with regulating massage establishments and practitioners in San Francisco for health, safety, and sanitation. The Department of Public Health believes in the therapeutic health services of massage therapy, but it also really sees the need for a more equitable regulatory environment and one that protects our city's most vulnerable populations. So for my presentation today, I'm going to give a quick overview of the state legislation and the proposed new legislation that Supervisor Tang already reviewed. And then I'm really going to focus on presenting what our current massage regulatory landscape looks like and some of the problems as a health department we have faced and the need for stricter enforcement. And lastly, I'm going to talk a little bit about our programmatic changes at the health department to provide more cultural competence services to our massage and other regulatory businesses. So as Supervisor Tang mentioned, prior to the preemptive state legislation, the health department regulated all massage establishments and practitioners in San Francisco. They all had permits, they all paid annual licenses, and they all paid cost recovery fees. In 2008, SB 731 created a new entity, the CMTC, which is a private, nonprofit, public benefit corporation. And the original intent of the CMTC was to create a voluntary statewide certification for massage practitioners. But in addition to this certification, it also created a loophole in the law. And what it did, if you, a massage business, employed 100% of CMTC certified practitioners, they were exempt from local regulatory permits and land use controls. In a little bit, I'm going to talk about this loophole. So last year, the mayor's office, the city attorney's office, the health department, and Supervisor Tang, we worked with state legislators to reform this state law, and the outcome was AB 1147. And what AB 1147 did was it returned land use control back to local governments and also gave local governments the ability to now regulate and permit massage establishments. So the legislation that I'm going to talk about today, this isn't really new legislation. This is legislation that we had prior to 2009. Additionally, we are going to allow all businesses to continue to operate as they apply with the CMT exemption as they apply for a permit. And the land use controls are only going to apply to new businesses. I also want to stress that these requirements are not new requirements by DPH. These are requirements that have already been in place, and we're just looking at removing the CMTC exemption. And one thing that I will talk about later in the presentation, in addition, the legislation does add additional enforcement mechanisms to strengthen our legislation. So this slide gives you a picture of the current massage businesses in San Francisco. We currently have 236 massage establishments that we know of operating in San Francisco. 90 of these have opened in the past 5 years with the CMTC exemption.
I'm sorry, what was that figure you said? How many?
We know of 236 massage establishments. So we have 146 that are permitted by the Department of Public Health. We have 90 that have the CMTC exemption. And we kind of estimated that we probably have about 60 to 90 other establishments that are operating with no business licenses at all. So the CMTC exempt establishments have no permits from the Department of Public Health and also no zoning controls from the Planning Department, which has created a couple of problems. One, we have estimated that 30 to 50% of these businesses are illicit and are potential hubs for human trafficking. As you know, human trafficking is one of the fastest growing crimes in the world, and actually 43% of the state human trafficking cases occur in the Bay Area. Additionally, the land use controls have created a clustering and density effect. 89 of the DPH permitted sites now are within 1,000 feet of the CMTC exempt sites. Also, we find that 70% of our establishments are now located in 7 neighborhoods. This includes the Richmond, the Sunset, the Western Addition, the Financial District, Civic Center, and Chinatown. So next I want to talk about some of the problems that we've seen within our massage establishments. I know many of us go to spas and get massages, and the pictures on the screens are probably pictures that we're not used to seeing. Our inspectors encounter a variety of situations and when we go into massage establishments. And this slide shows some of the types of violations that we see in our massage establishments. Often we find the exterior of these massage establishments include features such as window coverings, locked doors, and video cameras, which all have a negative effect on the neighborhood fabric. We see basic unsanitary conditions, the use of improper equipment, all which come into contact with customers' skin. Many times we see people living in the massage establishments, and these are violations around prohibited living quarters. People living in massage establishments are usually indicators that people are potentially being trafficked. And the health effects of people being trafficked are severe and numerous, and so are the impact of these businesses on our neighborhoods. So while the CMTC exemption has intensified land use controls and safety issues, as a whole, the massage industry has been problematic in San Francisco. The map kind of shows all of the violations of actually DPH permitted sites, and our biggest issue has really been around enforcement. Last year, our department released a report, and we found that since the inception of this program at DPH, we have revoked over 80 permits. And we found that about 60% of the establishments that we closed down reopened, and 30% closed and reopened multiple times. And this new legislation will have stricter enforcement mechanisms to prevent situations like this from happening. The previous map showed DPH permits, permitted establishments, and since we don't do routine inspections for CMTC exempt establishments, it's kind of difficult to compare violation history. This slide just gives you a snapshot of CMTC exempt sites. Just looking at 2014, there were 82 violations issued, and we've seen 39 very high risk violations and many other violations related to sanitation. We have closed 7 of the CMTC sites in the last year, and since they don't have permits, closing these illicit businesses has been very daunting for the health department and also very expensive. Again, we can't really compare inspections and violations from CMTC exempt sites and DPH sites. Most of our involvement in CMTC sites is complaint driven, but from the last map and from this charts here, you can see that many of these establishments are receiving multiple violations. The bar graph on the left shows that. In addition, we can look at the second bar graph on the right to see the rate of violations per inspection. And the point of the last map and these charts is not to say that CMTC establishments are less compliant than DPH permitted ones, but just that abuses are very prevalent among massage businesses regardless of massage professional certification. And it really shows the need for a more equitable regulatory environment and stricter enforcement mechanisms, like permits and land use controls. This will help us prevent illegal businesses from opening so we can make room for more law-abiding businesses to flourish in San Francisco. During my presentation, and we talked a little bit about human trafficking, and I just want to acknowledge that human trafficking is a really complex, systemic social issue. And this legislation is not going to solve all the problems, but it's a step in the right direction. As well as the health department supporting this legislation, we also have been working with the mayor's task force on anti-human trafficking and other collaborative efforts. In the last year, we have implemented a training program for all of our health inspectors. The environmental health branch has access to over 10,000 regulatory businesses, and now our inspectors have a unique opportunity to help with identifying potential victims of human trafficking. In this year's budget, the health department has put in a proposal for a healthcare worker. This healthcare worker would provide culturally competent education, resources, referral services to vulnerable populations within the massage industry and also our other regulatory businesses. Additionally, we're committed to improving our permitting and licensing process to make it easier for regulatory businesses. And we plan to do comprehensive outreach pending the passage of this legislation to ensure the vitality of the massage industry within San Francisco. I know today you're going to hear from many massage businesses in San Francisco that unfortunately have been misled by some of the massage professional organizations characterizing this legislation as punitive. This legislation is no different than how we regulate our other businesses in the environmental health branch. And the mission of the health department is really to protect and promote health, and this legislation serves that directive. Thank you.
Thank you very much, Ms. Comerford. Colleagues, do you have any questions for DPH?
No.
Okay. Seeing none, thank you very much. Appreciate that. I would like to next call up Diego Sanchez from our planning department.
Supervisor Diego Sanchez with the Planning Department. Supervisors, on March 26th, the Planning Commission heard the proposed amendments to the massage establishment ordinance proposed by Supervisor Tang. After deliberating on the matter, the Commission moved to adopt a recommendation of approval for the proposed ordinance with the following 7 modifications. First, to require all new and existing massage establishments to secure a permit through the Department of Public Health. Second, require a 3-year review of massage establishments for lawful operation and compliance with conditions of approval. Third, prohibit the reestablishment of a massage establishment in the same location that was closed due to planning, health, or other code violations for 3 years. Number 4, allow existing massage establishments to continue in operation while they secure land use approvals. 5, exempt sole practitioner massage establishments with only one sole practitioner from the conditional use authorization requirement. 6, reconcile the proposed ordinance with recent changes to Article 2. And 7, add a finding to explore an expedited conditional use authorization process for small businesses. This concludes my presentation, and I'm here for questions. Thank you.
Thank you. Through the chair, I think Supervisor Weiner has a question for Planning Department.
Supervisor Weiner.
Thank you, Madam Chair. Thanks for the presentation. Just a few questions, mostly relating to the issues I raised at the beginning, just to get the Planning Department's take. So in terms of possible, I guess it would be trailing legislation to allow in situations where a massage establishment in good standing with no violations wants to move to a different location, not requiring them to go through the conditional use process to do so. I just wanted to get the department's take on that. I know you don't have an official position, right, but just in terms of any initial feedback you have.
I think that's an initial proposition, interesting proposition in light of the current crisis we have with rising commercial rents. Typically, whenever a new business locates in a new location, they're subject to the land use approval entitlement process. So we would have to adjust that. I'd have to go back and speak with my colleagues and explore this, but I think we definitely can commit to looking at that option.
Okay, I'd like to just request that you explore that and provide us with feedback about it. The second would be changing the name. I guess it would be under Section 102 definitions in the Planning Code. Right now, it's the objection being we used to be classified as quote service, health. And now we're being removed and reclassified as massage establishment, and that sort of undermines the concept of it being a health-related profession. And so, just changing that to something like service, health - massage or something like that. If there would be any issue with doing that,
more than happy to look into that. I think that type of change can.
It's sort of. I mean, in a way, from the code's perspective, it seems fairly cosmetic. It doesn't have any impact on any controls, but for the profession, it would seem to be meaningful.
Definitely.
And that, I think, is a amendment we could make today. I don't think that would be substantive. In terms of the issue I raised earlier, where you have, so we now in the legislation, thank you to Supervisor Tang for her, for really listening and responding. Up to 4 massage therapists who are solo practitioners can co-locate without seeking a conditional use. Yet a single massage therapist who co-locates with a chiropractor or acupuncturist has to get a CU. If I'm understanding the legislation correctly, including the pre-existing legislation.
There may be a possibility where that chiropractor brings on that massage practitioner as a solo practitioner to take advantage of that exemption that's in the proposed ordinance. I mean, I think that we could definitely entertain this concern and look at ways to how to exempt that type of use from conditional use authorization, given the existing exemptions in the proposed ordinance.
I guess my first question then is, so if you have let's say an acupuncturist who co-locates with a massage therapist, and they're separate businesses, but they co-locate in an office together, under current law, do they have to get a conditional
That's
use? My
understanding, yeah.
Okay. So that would also be potential trailing legislation, so I would want to get the department's feedback on mirroring the up to 4 co-location rule. Okay. And then finally, if you are purchasing let's say you have and this came up because from a business in my district, we've got a lot of feedback from the massage profession, but you have an existing massage business, clean record, no problems, and someone else comes in and buys that business. My understanding is they typically, if they're just purchasing an existing business, would not have to seek a CU.
That's correct. A change in ownership doesn't trigger a land use.
Now, what if they are not technically, in terms of how it's structured, they're simply taking over the lease and not, but there's no sale of the actual business, and they're coming in and just setting up their own shop, and it's already been an existing reputable establishment for a long time? Would they need a conditional use?
I think we're concerned more about what the use is, not necessarily who's owning it, what lease arrangement there is, so to speak. So I from what you're saying, I believe that would not need a subsequent land use entitlement.
Okay, because I think, like, for example, if you're with Formula Retail, if you have Formula Retail,
Sure.
So if I have say a Starbucks or something that's a franchise, a franchised Formula Retail in a particular location, if you own it and I buy it from you, I don't think I need to get a CU. But if you were to vacate and I come in as a new Formula Retail in the same space, I would have to get a new CU.
For the Formula Retail, I think that's a pretty particular
Specific.
case in that situation. I'm not aware of too many Formula Retail massage establishments.
So frequently, or it's not uncommon in San Francisco, that for a restaurant to go into a particular location, it might need a CU, depending on the neighborhood.
Sure.
So if you were to own a restaurant and you shut down your restaurant, and then the landlord a week later entered into a lease with me, and I started a different restaurant there, would I typically have to get a new CU, or would that CU carry over?
The CU carries as long as it's that shutdown period. It hasn't been more than 3 years in the case of a conforming use.
Okay, and you think that applies here as well?
Yes.
Okay. Great, that's very, very helpful. And so we look forward to further discussions on those other two issues.
Thank you.
Thank you.
Thank you for the question, Supervisor Weiner, and I'm definitely happy to entertain trailing legislation based on some of the suggestions that you brought up. Two more departments I want to call up before we hop into public comment. I wanted to bring up Regina Dickendriese from the Small Business Commission.
Good afternoon, Chair Cohen, supervisors. Regina Dickendriese, Director for the Office of Small Business and the Small Business Commission. First, want to really extend my and the Commission's great appreciation to Supervisor Tang and Deanna Keyson and to Cindy Comerford and Diego Sanchez for attending the Small Business Commission hearing 3 times, and also with the great amount of work that they've done with the massage community. So the Commission, just to address the 2 pieces of legislation, the Commission did recommend to approve the health code regulation, really understand the importance and the need for the Department of Public Health to have a practitioner establishment permit. It's a good sort of blending of the CAMTC, and then also to have the establishment permit so that we have the opportunity to be able to provide some health and safety oversight to all massage establishments. And the Commission also really wants to appreciate both the Supervisor and the Department of Public Health for taking in the massage practitioner, massage community's feedback in increasing the massage hours, and also strengthening the fact that a massage location cannot return and reopen in the same location for 3 years. Much discussion was had at the Commission about the need for really raising and elevating the massage practitioners who are truly in the healthcare field as a means of being able to distinguish and elevate them and have absent sort of a really strong state definition that this is a means of being able to sort of begin to raise that bar and separate out the true healthcare practitioners from the non-healthcare practitioners. The Commission, when it did hear the legislation, it did it did, I think, having the understanding that because its recommendation was made on the non-substitute legislation, though Supervisor Tang had clearly laid out many of the amendments that she was making. But that the healthcare providers, as defined in the California Business and Code Division 2, which include chiropractors, acupuncturists, that they would not be required to have a massage establishment permit if they were having massage as an accessory use. So I think the Commission, Supervisor Wiener, in terms of some of the discussion that you're having here, would sort of support that direction. The Commission also recommends that the departments, both planning and Department of Public Health, do some real-time tracking in terms of taking a look at the effects of the legislation in terms of its effect in being able to either prevent establishments from opening and its ability to close establishments. And that also we're really supporting the healthcare massage practitioners in opening. The largest amount of discussion that the Commission had was around the conditional use, and I think that most of that discussion is a result of because of the conditional use process and the amount of time that it takes to get through the conditional use process. Massage establishments are not available or eligible for the community-based priority processing, which is an expedited processing for small businesses and small formula retails around the conditional use. In 2006, when the legislation was first changed over to the health department, and it did have a conditional use, at that time, many landlords allowed businesses to be able to kind of engage in a lease discussion, didn't charge them the rent while they were going through the conditional use process. We are certainly in a very different economic climate now, and so landlords are not rarely do I hear, and mostly landlords, when you're engaging in the lease discussions and you have to go through a conditional use, the individual is, or the business is, having to pay rent. And so for the Commission felt that for our healthcare massage practitioners, these are our small middle-class businesses. These are our middle-class individuals that live in the city. And so the conditional use process, as the process, apart from the means of needing to supporting the idea of neighborhood input, that is counterintuitive, really supporting our small and middle class businesses from being able to open. And so the Commission, the first matter of legislation that was introduced did not include the amnesty program, and so did not support that one, but made suggestions to the Supervisor Tang and to the Planning Commission to develop an amnesty program. And so I think the Commission hasn't taken final action on the substitute legislation, but is very much in support of the direction that Supervisor Tang has taken this legislation with the amnesty program. I think is going to address many of the concerns of our existing practitioners being able that they will be able to stay in business. I think with the change, I think Supervisor Wiener, with some of the other sort of, as we take a look at the planning code, some of the things that sort of that the Commission had some discussion with at their last meeting, is that if you do have a healthcare practitioner who does have to go, currently as it stands, is required to go get an establishment permit and go through the CU, what we do have in our planning code right now is that there are certain areas where medical services, which is what like an acupuncture or chiropractor would be classified as under the planning code, medical services are allowed, but massage establishments are not. And so how do we address that if a chiropractic office wanted to be able to have massage as an accessory use, would they be able to apply for a massage establishment permit if massage is not allowed in that zoning area? So I think that those are some things that we really need to take a closer look at as we move forward in terms of how do we line up really working with the goals of really wanting to really have our massage, the healthcare side of massage and the practitioners really be a robust and a viable means of living and a viable means to our healthcare delivery in the city, to sort of take a look at some of these unique elements. So with that, and again, just really want to express appreciation for Supervisor Tang for the amount of time that she spent with our commission and hearing their concerns and addressing it. So,
Thank you very much, Ms. Dicondresi.
I have a quick question for Ms. Dicondresi. Quick question for you. One of the things that I heard from many of the coalition and of the constituents is that there was a request for a continuance for more time and more outreach. And that's something that we get often. I was wondering if you could talk to me a little bit about your process in notifying your small businesses about this particular issue.
So in terms of, for our office, we notified either through the merchants groups, where I know that either massage is part of the membership, businesses that have come into our office, and then those that we have interfaced with through the past. There were, through previous reiterations of the massage changes to the massage regulations over the period of since 2009. We have also accumulated a list of different entities, organizations, the schools, things of that sort.
So you solely you rely on email and your members?
Email, phone calls, things of that sort in terms of outreach. Again, I don't, with the small staff, didn't have the ability to do a mailing or, outreach to all the licensees.
Thank you.
Through the chair. So also, just to build on that, our office actually sent out about 200 letters to massage establishments. We're not allowed to send out more than that per law or per our ethics regulations. I know our city attorney's nodding his head. So we actually, as Cindy mentioned, we have about 230-something on the books. And so we sent out physical letters to these businesses to let them know at the very beginning what our goals of the legislation was, some of the outline of what it was going to look like, and then to contact our office with any questions and concerns. Since then, we've received phone calls from many establishments, many of whom are actually not here today because we were able to answer many of their questions and they were fully permitted.
Thank you. Okay.
Thank you. And with that, I'd like to call up our last department speaker, Sergeant Flores from our San Francisco Police Department. Although jurisdiction over massage has gone over to DPH, our SFPD has been a huge partner with us on this effort.
Thank you, Supervisor Tang and board's supervisors. I want to thank you and your office for taking on this venture. As you know, especially the folks that we worked with closely in our nonprofit groups, when this was brought to my attention probably about 4 years ago, I went out doing my first inspection, and it was probably that time that I really understood what it was for these individuals. And coming from a victimology background in the Special Victims Unit, where I could see that domestic violence and human trafficking literally mirrored each other at that moment, especially doing these inspections with the individuals and the department heads that were there. How we come in contact with a lot of these cases are through our human trafficking hotline, through complaints through the community, and also from the victims themselves after we conduct these inspections, where those individuals will be provided with services and then later on feeling that they're able to talk to us because they feel comfortable to talk to us and provide us this information. And again, what you're doing for us, for the whole community that deals with the massage establishments, is weeding out the good from the bad, setting those folks up that we want to see this decrease. But obviously, I'm pretty sure the stakeholders that are here in this room today are not the ones that we are investigating regarding human trafficking. And we like to see that, and we like to see more of that. When we come in contact with those victims that we believe that are victims of human trafficking, it's very frustrating to conduct these interviews with these individuals, with them looking over, glancing at the owner or the controller of of these establishments that look over for answers or responses, especially when we're asking about the permits and if they have their passports. Again, these services that we provide and having these posters up, before those numbers even went up, I used to give this information, write it down on a piece of paper or actually program it inside the victim's phone and telling them this is a safe number for you to call. Again, we support this legislation, and I take any questions.
Oops, sorry. Thank you, Sergeant Flores. And just for public knowledge, if you could just clarify, now that the jurisdiction over massage establishments is under DPH, what role does SFPD play? I mean, in what way? Through the task force, for example, or do you go on the routine inspections of the establishments?
Sure. Again, working closely with Ed Walsh on these matters. We'll constantly be in communications. If we receive information of a complaint regarding a certain spa or establishment, I'll contact Ed, and then we'll put that individual on our list of inspections, and then we will go to either prove or disprove the facts. And as we go inside, my focus is to really to understand the folks that are working in these establishments, and they are hardworking folks. I tell you that right now. And to kind of alert them and let them know their rights, and also if there's labor violations, to kind of bring that to their attentions, and they can communicate with us either there or later. We've assisted individuals as we're conducting our interviews with these individuals that you can see in their look in their eye, and I'll say, do you want to leave right now? And they've literally said, yes, I want to leave right now. Or we will help them pack up their stuff, their suitcases, and give them safe passage out of the establishments, and then again provide them services so they can leave. My focus is the criminal investigation regarding the establishments and the owners, and hold the owners accountable for if we believe that there's human trafficking occurring inside those places.
All right, thank you very much. Any questions from committee members? All right, thank you to all of our department speakers. So at this point then, through the chair, if I can open up public comment.
Yes, please.
And I have a number of speaker cards here. If you haven't filled one out, please do so. Otherwise, you'll still be allowed an opportunity to speak. First, I'm actually going to call up Fiona Ma, who's from our State Board of Equalization, given her role in this effort. And then I'm going to call up a few more cards. If you can please line up by that window right there. Stacy DeGoyer from the San Francisco Massage Ordinance Advisory Committee, London Elise, Tony Siakatos, and Gary Witt.
Thank you very much, members. Shortly after I got elected to the Board of Supervisors in 2002, there were 2 homes that were raided in the Sunset District. 2 groups of women from Korea were trafficked here to the United States, and it was at that time that I got sucked into the world of human trafficking. Norma Hotelling of Sage at the time came to my office and educated me on the plight of many of these women who are forced here, their passports taken away, they're stripped of speaking to their family members, the shame that they feel for, being involved in this, and the victimization that these women feel, not only being duped most of the time, but also now being involved and trapped in this world. So we looked at numerous ways of trying to combat this issue. We looked at asset forfeiture for the people who own the properties and knowingly know this is going on. We looked at increasing penalties and crime statutes. But ultimately, we settled in 2006 on requiring a conditional use permit for these establishments to open. It requires the owner to come before the commission, show who they are, talk about their business, practices, and really shed light on transparency. So I think it really did decrease the amount of illegal massage parlors and human trafficking that occurred in San Francisco, and I'm very thankful to Supervisor Tang for trying to bring back the original ordinance. Thank you, members.
Thank you very much.
Good afternoon. The massage ordinances before you are being viewed through the lens of human trafficking, and the massage community has been an afterthought. A simple example of this is today everyone who's been invited to speak for longer than 2 minutes is a human trafficking advocate, and everyone is seeing the nail that's sticking out higher and forgetting about the providers that offer massage as a healing art. A few things that I want to address is we would really like to continue to be seen as professionals, and we could do that if we had the declaration of exemption massage establishments becoming certified establishments, and that this group could actually be exempt from having to go through the conditional use permit. We're like massage therapists are categorized by the state as healing arts professionals. We're a different chapter. We're chapter 10.5 of the state code, just like a chiropractor or a physical therapist or an occupational therapist, and we're not being given that recognition. Also, I have a concern about the massage permit to practitioners. Currently, in the law, the sole provider has been able to have the higher credential of a 200-hour permit. And
I'm sorry, I have to just interrupt. The clerk of the board just reminded me of a rule that there's no banners or posters allowed within the chamber. So I need you just to speak to the content on the banner, but speak to without displaying it. Thank you.
So currently under the law in San Francisco, advanced massage practitioners are allowed to get a sole fixed establishment. Now, everybody's going to have to be a 500-hour tiered practitioner by DPH, and we're wondering if all of those 100-hour trained professionals, permit holders, are going to be grandfathered into the 500. Are they going to have to go back to school? And then are they also going to be able to open their own establishment? So it's almost like we're lowering the tier for the profession, which could also be a huge loophole for human trafficking. So we're not addressing human trafficking with allowing that, as well as not allowing.
Thank you. Before you go, I just wanted to let you know that if you'd like, you can make a copy, put the content of the poster on a piece of paper, and we can put it into the file for the record.
Thank you.
Nick, we have a question for you, Supervisor Weiner.
What you just said at the end, I didn't fully understand in terms of the 500 versus the 100. I just want to make sure I'm understanding what you're saying.
So currently, under the ordinance, there are two categories of massage providers. The first one is a general massage provider, and that education level is 100 hours. The second one is an advanced massage practitioner, and that's 200 hours. But the new ordinance is proposing that all massage therapists have to have 500 hours of education, which is the state level. But what's happening to all of the current permit holders? There's no grandfather clause in the proposed ordinance.
Okay, Madam Chair,
Through the chair, if I can just speak to that issue.
Supervisor Tang.
Thank you. So per suggestions actually from several people from the massage community, we actually are increasing the number of hours required of training to 500 hours to match the CAMTC requirements. We actually did this because we had heard that it would be better to actually align some of our local requirements with the state requirements. And so that is why we did that. I believe that all, and DPH can correct me if I'm wrong, but those who are currently going through the process, they will be fine with the previously required hours. This legislation, the new requirements will only kick in, 30 days after it's been signed. All right. Thank you. Next speaker, please.
Thank you for hearing us all today, supervisors. My name is London Elise. I'm a California state licensed esthetician, and I've been the owner of Soothe Spa for the last 10 years here in San Francisco. And I've been a spa professional for 20 years, acting as a consultant, previously a massage therapist and an esthetician. While no one in this room wants human trafficking in San Francisco, this legislation will not stop it. The cost to open a legitimate business that offers massage therapy will become so high that only criminals will be able to afford it. Nowhere in this legislation does it detail the costs associated with going through the conditional use permitting process or mention any of the costs of paying for all the inspections, permits, and required changes of the Department of Building Inspection and the 13 divisions within their department that will be required of people opening. Real massage therapists don't have that kind of capital to jump through these hoops, but well-funded criminals do. Plus, once their establishment gets a conditional use permit, it can be sold to any criminal as the CU permit is tied to the location, not the business. Using conditional use permits and the health department is not an effective law enforcement tool and will not be able to protect and give amnesty to these victims. The only way to stop trafficking and give the victims a fighting chance at a future is by engaging the police, the DA, and various federal agencies who can close down these illegal businesses with with uncertified victims being sold as massage practitioners. They will need state and federal support to get the aftercare and financial, legal, emotional support they deserve so they can start their new lives. This legislation is going to gut the healing arts community in San Francisco, forcing all healing arts practitioners to go through conditional use and charging the still unknown costs to be allowed to practice massage. And it will only close down the legitimate people and prevent state-recognized healing arts professionals from
Okay, my friends, I know you're enthusiastic, but we have another board rule that I just want to remind you of, and that is no applause. I know it's a bad rule, and it's no fun, particularly when you hear something that you like, but it helps us keep the business of this agenda moving forward. So when you hear something that you like, I'd like to offer you to shake your fingers like this, spirit fingers, when you hear something that you like. And when you hear something that you don't like, just a simple thumbs down. No booing, no hissing, no applause. I know it makes a very boring meeting, but it allows us to move a little bit more expeditiously. And also just want to remind everyone that's speaking for public comment that you each have 2 minutes. Thank you.
Good afternoon. My name is Rosalind Solon. I represent the Junior League of San Francisco. I'm the current Public Affairs Council Director. We're here to support Supervisor Tang's ordinance for massage parlors regulation due to the fact that San Francisco has been named one of the top 5 human trafficked places for young children, not just for sexual but labors as well. This is one of the places that where not just places where children are now currently being hidden in homes, but also being used in massage parlors as workers. So we are hoping that Katie Tang's ordinance will continue, but I know that we want to use all these ordinances to use land use and licenses, so we do hope that these licenses will continue to be more regulated and that we will continue to have more aspects and getting more regulations up and running, and that we will utilize these laws. And we know that finances is not as great as there's all these inspections that's going to happen, but we hope that we can all work together on that. But we do also want to protect our communities. We do have a lot of children and low-income families, and we can't have all these criminals running around our city if we want to continue to live in this town. So we do support Katie Tang in this effort in protecting our communities.
Thank you. I'm going to call up a few more speakers. If you could please line up by the window. Amanda Leitner, Beverly May, Adam Gordon, and Julie Sue. Please come on up.
Hi, good afternoon. My name is Gary Witt. I am the owner and director of the San Francisco School of Massage and Bodywork. Our school has been in continual operation in the city of San Francisco since 1969. Over 45 years and counting. It is in my opinion that the proposed massage legislation as it is still currently written will create an enormously expensive and overly burdensome permitting process that will severely limit our graduates and other local massage school graduates in seeking out the rewarding small business opportunity of starting and owning their own massage business. While it is true that the changes have been made to the proposed legislation exempting solo practitioners from the CU process, the fact still remains that if I or anyone else in this room wanted to start a massage establishment business today and employ massage therapists, we'd be forced to go through the very tedious, onerous, expensive, and extremely unfair process of the conditional use permit. As I'm sure you're all aware, the burden of having to go through the conditional use is a very expensive and time-consuming ordeal. It is certainly well documented that the CU process can take extremely long time to be approved, sometimes as much as 9 months. In that time, the massage business owner must have secured their space by signing a lease, and then will have begun the very expensive lease payments, all while the CU process drags on and on. And as you can imagine, paying these enormous rents on spaces, all the while never realizing any income at all, is certainly a death knell for any small business owner. The illicit and illegal massage businesses we speak of can certainly withstand this type of financial burden. Legitimate massage small business owners most assuredly will not. They will simply never open or won't even try to open a massage business in San Francisco. They will just simply go elsewhere. Again, in my opinion, the conditional use requirement must be written out of the current proposed legislation. Not only is it extremely expensive and overly burdensome, it's also unfair and discriminatory. No other comparable or like profession or business in SF is forced to go through this arduous, expensive, and overregulated process. We must work together to find a better way of weeding out the bad actors. We all want legitimate, hardworking small business to stay.
Next speaker.
Good afternoon. I love speaking after Gary Witt. My name is Tony Psychotis. I'm the Government Relations Chair for the American Massage Therapy Association, California chapter. As a massage therapist, and as advocates for our profession, we often end up in this position. How could we possibly be against the struggle to end human trafficking? Well, it's pretty simple. We're not. We are in favor of ordinances that actually regulate massage. Sanitation, record keeping, these are issues that pertain to massage therapy. Enslaving employees, keeping living quarters in an establishment, and performing sex acts have nothing to do with the practice of massage. Massage therapists do not do these things. They do not run these establishments. Criminals pretending to run massage businesses do these things and run these massage businesses, these establishments. As a rule, the massage profession does not have bad actors. It is harmed by imposters, outsiders, and criminals. And there's nothing magical about using massage as a cover for sex trafficking. A conditional use permit may stop a criminal from pretending that their brothel is a massage establishment, so they'll pretend it's something else. We have one choice to run a legal massage business in this city: comply with the city ordinances. Criminals will find another cover for their human trafficking. Massage therapists without deep pockets will open their businesses somewhere else. Thank you.
Next speaker, please.
Hello, supervisors. My name is Amanda Leitner. I am a massage therapist and small business owner in San Francisco. I have 1,000 hours of training. I have been practicing for 12 years. I'm nationally certified and I'm state certified. I have done everything in my power to differentiate myself from those bad actors. I am all for legislation that helps differentiate massage therapists from massage parlors. I just heard that word used again. Everybody who's in this profession knows that a massage parlor is not a legitimate business. Let's use enforcement tactics against massage parlors so they come out from hiding under our legitimate title. And I really support the San Francisco Department of Public Health and the police department to work carefully with organizations like the CAMTC to make sure that that is being done. I am all for somebody coming in and inspecting my business to make sure that I'm a legitimate business. The conditional use, that is the barrier to entry that is being proposed, is not that fail-safe. It will only keep legitimate people from going forward. I do appreciate that some exemptions are being made, trying to help people who are already in business stay in business. There are still issues with that, considering underlying zoning regulations, that the zoning is changing out from under us. So I would still like to see that addressed before this legislation is approved. And either way, going forward in the profession, it's simply unfair for somebody who wants to open a legitimate practice. Thank you for taking these things into consideration.
Thank you very much. Next speaker.
Good afternoon, supervisors. I speak in support of the legislation proposed by Supervisor Katie Tang. I am Julie Sue. I'm a current commissioner on the San Francisco Commission on the Status of Women. I'm also a co-chair of the San Francisco Collaborative Against Human Trafficking, and I've been a regulatory attorney for a state agency for the past 14 years. As you've heard, through the FBI and International Labor Organization statistics, California is one of the top 4 state destinations for human trafficking. The FBI statistics places the San Francisco Bay Area on the top 13 list. For every 1 sex trafficking victim, there is an estimated 9 victims of labor trafficking. We need to take appropriate preventive measures, and I think Supervisor Tang's proposed legislation takes those appropriate measures without being overly onerous. The mayor indeed has seen human trafficking as a top priority for the city and formed a human trafficking task force in March 2013. The commissioners for the Commission on the Status of Women have gone out to do education, outreach, and held conferences on human trafficking, and indeed has placed as a policy priority for the department to work on human trafficking issues. Legitimate businesses should welcome a strong regulatory infrastructure to stem unfair business practices of businesses who do not comply, but also illegitimate businesses. This is not meant as punitive, but for the protection of the public. Prosecution is expensive, more than just law enforcement and the justice system. There is a human cost. Most vulnerable people are engaged as victims of human trafficking: immigrants, women, and children. And the average age, I'd like to remind the supervisors, is between 13 and 14 years of age. So these are the victims who cannot speak for themselves, and that's why we're here today. Thank you.
Thank you. Next speaker, please.
Hello, I'm Beverly May. I'm Director of Governmental Affairs for the California Massage Therapy Council. CAMTC doesn't have any interest in how San Francisco treats those with DPH massage permits. We've been mandated to keep prostitution and the sex industry out of the legitimate profession of massage through our certificate program. Last year, after many of requests, we finally got some information of incident reports for sexual activity in massage businesses from DPH, and we've taken action or taking action on all of them. Unlike any other city, San Francisco never makes arrests. Citations get dropped, fines are not issued, and there's no DOJ reports. If the city doesn't give us information, we'll never know and be able to take action. So personally, I hope that you lower the standards so that the illicit people don't even come through our program. While San Francisco from what I've seen, has yet to confirm a single victim of human trafficking within massage since perhaps 2004, or rescue anyone, it's a shame and a disservice to the legitimate profession and the rest of California cities and counties to not codify and commit working with CAMTC in denying or disciplining those providing sexual services. In over 20 years of speaking at city council meetings where massage ordinances were being considered, I've never once seen one without any representation of the illicit industry. And the 2 $600 an hour attorneys who show up at all the DPH hearings have not been at any of these hearings. Why? It's obvious the illicit industry sees no threat from this ordinance. Thank you.
Thank you. Next speaker, please.
Thank you. And I just wanted to, since this is a representative from CAMTC, I just wanted to confirm if you're speaking on behalf of the entire CAMTC or your personal opinions. If you could just state it in the mic. Sorry. Thank you.
This is I have not had a chance to run these my comments through our board, but this is the position: is that we do not want we want cities and counties to regulate prostitution and to work with us. And it's also the position of the legislature is that cities and counties, it's in the intent of AB 1147, is that cities and counties share information and work together with CAMTC.
Okay, just wanted to clarify because CAMTC is in charge of issuing permits and also enforcement, so I just wanted to make it clear which position this is coming from. Before I call up the next speakers, before the next speaker, I want to call a few more cards. Sasha Cardenas, Grant Earnhardt, Kathleen Wyckoff, and Wesley Cabral.
Good afternoon, supervisors. Thank you for considering the point of view of the industry. My name is Adam Gordon. I'm the owner of Oxygen Massage Therapy. I employ approximately 30 massage therapists in the city in 3 locations. First, I do want to say thank you to Supervisor Tang for the amendments on legitimization. Really grateful for the efforts to preserve existing businesses, and to Supervisor Wiener for the proposed trailing legislation. That's the first I've heard of that, but those sound like workable solutions. As far as being treated fairly, and the representative from Department of Public Health had said that we are misleading our constituents and saying that we feel we are being treated unfairly, and I just wanted to explain what we feel is unfair. We've spoken many times about being classified as a healing arts profession on the state level, along with acupuncturists, chiropractors, and a number of other accessory medical professionals. When we look at the regulatory structure that the city applies to those professionals, none of them have to go through anything close to what we have to go to. When we look at other businesses that are being put through what our businesses are being put through, we see cannabis dispensaries, we see large restaurants, we see bars, we see businesses that generally have a huge amount of capital and are not healing arts professionals. We're often much smaller, much lower funded professional services. The other thing that's just worth bearing in mind is that there is a patchwork history of land use where massage therapy is in fact completely zoned out, as Regina Dickin-Tracy pointed out, of a number of districts where there's a very good purpose to have massage in those locations, and chiropractors, acupuncturists, and other healing arts professionals would be allowed. The reason that on the state level there was a pushback was because massage therapists did feel we were being treated unfairly, and let's not swing the pendulum all the way back to where it was. Let's move forward. Thank you so much.
Good afternoon. My name is Sasha Cardenas. I'm a certified Rolfer, a CAMTC certified massage therapist, and the owner of Inline Bodies in Bernal Heights, where I provide contract employment for other CAMTC certified practitioners. In my practice, I treat serious injuries, chronic and acute pain disorders, and help members of this community, many of them referred to me by physicians and surgeons, to live active and productive lives. Yet because I provide hands-on therapy, the regulatory framework proposed presumes that despite having gone through background checks, transcript verification, and fingerprinting at the state level, my business should be categorized and regulated as adult entertainment. I sincerely appreciate Supervisor Tang's effort to design an amnesty program for certain existing practitioners and businesses. However, the current language is unclear as to how amnesty would function in practice. Even for a sole practitioner, it appears that the proposed amnesty would end up costing nearly $2,000 in application and inspection fees from the DPH permit alone. If a space is shared by 4 sole practitioners, that single office would have to be inspected no less than 16 times, once each by fire, police, health, and planning for each practitioner, at a cost of nearly $8,000 for what might be no more than a single room in a facility such as Active Space in the Mission. This is radically out of proportion to the scale of a sole practitioner's business, possibly more than a year's share of rent for such a space, and likely sufficient to deprive many honest clinicians of the ability to earn a living in the profession for which they've trained. Clinicians unable to qualify for amnesty will need to pay nearly triple that amount for fees simply to apply for the conditional use permit. And since most legitimate massage establishments rent office space within existing commercial or medical buildings, we have no power to make structural changes. Meeting the new requirements established in the current proposal is by no means certain. Thank you.
Next speaker, please.
Good afternoon, supervisors. My name is Grant Earnhardt. I'm also a certified Rolfer and a licensed massage therapist through the Department of Public Health. I don't have a prepared statement as many other speakers here today, but I do want to say that it does feel, having read the legislation, that the framework that's being put in place is not fair to someone like myself who's a solo practitioner. If I understand I potentially could have amnesty or be grandfathered in, but I for sure would not have had the resources to start my own individual practice under these conditions. As many people have said before, I do feel human trafficking is a big concern, but I don't see the language in this legislation that would differentiate, or set the net that's actually going to have an impact on that issue. It does seem like it's setting up general, large-scale hurdles for people who want to start legitimate small-time business. Thank you.
Thank you. Next speaker, please.
Thank you, Supervisors. My name is Wesley Cabral. My wife and I run Earthbody Day Spa in Hayes Valley. We've been there for 10 years. We serve 300, 400 clients every month, a lot of San Francisco and Bay Area residents providing massage services. I'm in full, absolute support of legislation that's going to put an end to human suffering and to the abuse of individuals. However, I don't feel like this legislation is doing that. I think you'll have all of the legitimate massage businesses in your system, but you still won't have any of the illegal businesses in your radar. And you'll actually be I don't see how we'll be in any sort of a different situation or landscape where there's going to be any more idea of where these illegal massage, let's not even call it massage, as a fellow colleague said, where illegal action is taking place. As Sergeant Flores says, the people in this room are not the ones that are going to be investigated. We're the ones that are going to have to bear the burden of making this legislation happen financially and with our time. You still won't know where the bad actors are. And I guess my main concern is that myself, having a business in the city established for 10 years, I'm really concerned that this is actually going to create a huge hurdle for us. I don't know if actually massage is allowed in Hayes Valley without a conditional use permit. The zoning laws are very confusing, and so I'm just really concerned that good businesses are going to be burdened by this, and that new massage practitioners won't be able to practice in the city.
Thank you very much. Next speaker, please.
Good afternoon. My name is Kathleen Wyckoff. I'm a recent CMTC massage therapist. I am not practicing yet, but I hope one day to have a business in the city. And I'm very concerned about the permits and the licensing and the CUP processing. I do thank Supervisor Tang for being concerned about human trafficking. I am too, but I feel that legitimate practitioners are being swept in under the same umbrella. And I would also like more time to look at the legislation and seeing how it's going to impact me to work in the city in the future. Thank you.
Thank you. I'm going to call up a few more speaker cards. Jordan Lowy, Michael Neufeld, V, Nancy Goldberg.
I would like to just echo some of my other massage therapists and their concerns about item 2, the permit. I have been a massage therapist in San Francisco since 2000, have been a CAMTEC permitted person since its inception. I have just gone through and gotten my permit for acupuncture from the California Acupuncture Board, and now I'm concerned with these permit processes. I will be unable to open up an establishment in the city, as I would also like to be able to offer massage. And I'm definitely concerned with some of the things that Supervisor Wiener brought up about co-locations. And if I would like to have a business that's run by 2 people and not just co-locating, this would make it very difficult for us to get our permits and open up establishment. And also, I do think it's unfair for a chiropractor or acupuncturist to not be able to have at least one massage therapist co-locate with them. I'm all for the legislation to help human trafficking, but I do not think this permit process is going to do anything to do that. And like all my other people in the profession, it's going to just prevent us from being in business, and you're going to see an exodus of all this type of business in San Francisco to other cities around the area. Thank you.
Next speaker, please.
Hi, I'm Nancy Goldberg, and I'm here wearing a few hats. I'm involved with the Jewish Coalition to End Human Trafficking, co-chair with Julie Su in the San Francisco Collaborative Against Human Trafficking, and I'm immediate past president of Jewish Family and Children's Services and on their board. I've heard some very compelling things said here today by both sides. I still feel that this legislation gives us the tools that we're going to need to regulate the massage parlor business. We have an adult day health care center in the Sunset, and the massage parlor business around that is just proliferates. The minute one is closed down, another springs up, and it just is a very, it feels not safe for a lot of our clients. Other counties have come to me to see the ordinances, what we've done here in San Francisco, and I just want to thank Supervisor Tang and certainly Deanna Quizna for all that they've done. And I just urge that this be passed and some way to accommodate both sides. Thank you very much.
Thank you. And I think I see Robin Brasso lined up. Is that right? No? Okay. Anyone who didn't fill out a card, please do so. Dr. Frank Gilson, I'm going to call up a few more. Eugenie Pakopax. Corey House. I apologize if I can't read some of the handwriting here. Carol Ito, Gladys, and Mary Jung.
Next speaker, let's go. Ms. Ito.
Good afternoon, Chair Cohen, Supervisors Tang and Weiner. My name is Carol Ito. I'm a former president of the Commission on the Status of Women and a longtime advocate for women, and particularly immigrant women, who have suffered through a number of different industries in terms of abuse and being taken advantage of. And I just want to thank Deanna and Supervisor Tang for taking the time to do this thorough investigation of what needs to be improved. As Fiona Ma, member of the Board of Equalization, noted back in 2006, she made some attempts. There are some holes in that attempt. Some things worked, and I believe that the current legislation affecting the health code and planning code will bring us up to date in terms of seeing what kinds of things we can manage better. I know that the therapists who have testified are concerned about these unintended consequences of their business. I'm a small business owner, and I work with a lot of small businesses in the city, and I realize what the cost of doing business here in the city is. However, I think through you're perhaps working this through the Board of Supervisors, and I'm not thoroughly informed about some of the specific complaints that were raised today, but I believe that overall the legislation, the intent is important for the city to deal not just with regulating a legitimate business and providing safe, quality services for citizens like myself that use these services, but to protect the overall population that is being taken advantage of. Thank you.
Thank you. Next speaker, please.
Good afternoon, supervisors. My name is Corey Hollis, and I'm a student at National Holistic Institute. I haven't prepared a statement, but as many of the therapists here and on the other side of the fence, they have said everything that possibly needs to be said. But I would just like to make a statement and say that I agree with Supervisor Weiner when he's stating about the chiropractors having extra massage therapists on hand, because something that wasn't brought up about this is something that's called allied healthcare practitioners or wellness centers. And usually the ones that I have seen or came across, they usually have at least 2 or 3 therapists on hand with naturopaths, chiropractors, and acupuncturists. So businesses such as that will get hurt big time because, like I said, there's usually 2 or 3 on hand at all times. So, yeah, what are they going to do about this bill that's being passed? And of course, in myself, I would like to work with other healthcare practitioners because I find that I am myself a healthcare practitioner along with the rest of them. Massage is not just a touch and you're done. You know, we actually do stuff for people and bring health and wellness to the body. That's all I really have to say. I just wanted to state that I do agree with Supervisor Weiner that something should be added in that bill, and that something should be added in that bill to say that we are healthcare practitioners and not massage therapists. Thank you.
Good afternoon. My name is Mary Jung. I'm a resident of the West Side in San Francisco. Most recently, I was a member of the Commission on the Status of Women. I've been on those on the massage parlor tours that Executive Director Emily Morassi was talking about, and it was quite an eye-opener. And if any of you have not gone on one of those inspection tours, you definitely should go to one of them. I want to thank Supervisor Katie Tang for bringing this issue to light and working so hard on this issue. And I also want to thank Supervisors Scott Weiner and Malia Cohen for your thoughtful suggestions and your thoughtful questions. I know that we're headed in the right direction. We have many massage parlors in this neighborhood. Some of them are questionable, and I know this from personal experience, having tried to get a professional massage myself, sometimes successfully, one time not so successfully, and that by itself was an eye-opener too. A conditional use permit is appropriate in this situation and could help weed out some of the bad actors. A lot of the businesses require conditional use permits, and I don't see why massage parlors should be any different. Supervisor Tang's legislation is thoughtful, and the proposed amnesty will protect many current businesses. I did hear one of the testifiers talking about the high costs. I would hope that it's not quite that high, but and I know that people are complaining about that, and I get that, having been a small business owner. But if you know of anyone who could possibly be in this situation, if you have a family member or a friend, even the untold people that you don't hear about, if you could save one life, wouldn't you want to do this? So anyway, I'm asking you to support this legislation. Thank you.
Thank you. Next speaker, please.
Thank you. I'm going to call up a few more cards. Nancy Rock, Susan Pfeiffer, Anthony Rutherford, Wiley Jackson, Aaron Riley, and Andrew Yip. If you could please line up. And that's all the speaker cards I have, so if I haven't called your name, just please come on up to the window. Thank you.
Good afternoon. My name is Eugenie Pakopak. I'm a massage therapist and a sole provider. And I'd like to stick to conditional use permitting. AB 1147 gave control back to the cities with the intention that we are regulated with other healthcare practitioners, acupuncturists and chiropractors, etc. And I've checked. Chiropractors and acupuncturists need a professional license and a business license to operate in the city. And I don't think we can speak enough that we do not want to see, more than probably any other industry, these bad actors hiding with our storefronts. We're not massage parlors, we are legitimate massage businesses. And I'd like to speak because we are the smallest of small businesses. I had the wonderful opportunity to be a part of a massage establishment. It started with one therapist who was able to bring on me, the second staff, or the first staff therapist. And that's how it grows. And then we get busy enough to get a third and a fourth. And one day, I would like to have my own massage establishment, but with conditional use permitting, there's no way I'm going to get beyond just me. That's my future, stuck as either a sole practitioner or an employee and never having that opportunity. And there's many other therapists out there who cannot be here today who would also like that opportunity. Thank you.
Next speaker, please.
Hi, yes, my name is Anthony Rutherford. I am a CMT certified massage therapist as well as a pediatric massage therapist. I want to say thank you to the supervisors for your proposed legislation. It goes far, but it doesn't go far enough. What you're doing is you're putting blanket regulation over top of what is a very negative issue, yes, but at the same time you're grouping it with what is viewed as a health profession. We've taken a long time for massage therapy to become recognized as a viable health practice for people to become better and to live more healthy, productive lives. But with this regulation, you're not thinking of the unintended consequences when you put massage therapy businesses out of business, but you put the massage parlors in business. Those people that want to seek a massage, where are they going to go? They're going to go to a massage parlor because they think, from what you're going to say, is a viable business, but at the same time, they don't know that because you're taking away that health and service practice from massage. So when people go into these massage parlors, they're going to think they're going to get a massage, but as you were saying with human trafficking, they might get slipped up under the rug if it's a woman, if it's someone else that's not an understanding what's going on. But what AB 1147 states in Section 4600.5, Section D, it is the intent of the legislature that local governments, law enforcement, nonprofit stakeholders, and the massage industry and massage professionals work together going forward to improve communication, share information to further increase the value of statewide certification, to collaborate the implementation of this act, to develop a model ordinance reflecting best practices in massage regulation for cities and the counties to adopt that will respect local control, patient privacy, and the dignity of the profession of massage therapy. You are going against that. That is double speak, and I hope you are realizing that you are giving taxation without representation to us massage therapists here. This goes back to what this country was founded on, so I hope you are grateful for that. Thank you.
Good afternoon. My name is Erin Riley. I'm a certified acupuncturist by the state of California as well as nationally by the NCCAOM. I'd like to thank the supervisors and the various departments for their efforts in halting human trafficking. No one is arguing in favor of human trafficking here. A salient point, though, I heard Sergeant Flores from the SFPD report that the police department becomes aware of victims from victims themselves and their outreach programs. I believe that this is very well-intended legislation. However, it doesn't appear to be the appropriate way to go about it without assessing numerous expensive fees to various businesses. Regarding co-location, an important point is that often acupuncturists, chiropractors will have multiple massage therapists on staff. This is because massage therapists are often part-time workers, and acupuncturists and other healthcare providers may have multiple offices in multiple cities. So that, and same thing with the massage therapists. So the one-to-one co-location seems to be problematic. I'd appreciate if you could look at that. Prosecuting human traffickers to the fullest extent of the law is absolutely the right thing to do. This legislation does not seem to be the best way to accomplish it. I would like to request that the board take additional time for review and outreach. Thank you.
Good afternoon, supervisors. My name is Wiley Jackson. I am not a massage therapist. I am just a native of San Francisco, born and raised in the Western Addition, with many friends in the healing arts community of my city. I am concerned that this legislation, regardless of the noble goals it aspires to achieve, will in fact have the opposite effects. The argument that this legislation is just taking us back to 2006 is misleading. This was discriminatory in 2006, and when has going back ever been good for legislation? Massage is growing in respect and its efficaciousness, and the law should evolve with the profession. This legislation is pulling CAMCT, certified massage therapists, out of being characterized as medical use and singling them out as separate, much more restricted land use. The city should show proper respect for the massage profession alongside other professions. There's no evidence the 2006 law did anything to effectively reduce human trafficking or prostitution. While they, more than anyone else, want to see criminals kicked out of their profession, this does not achieve that. What it does do is hamper small business with a process that no other healing arts profession is subject to. Conditional use is not a law enforcement tool, it's a planning tool. And if there were going to be a stigma with massage, there would be no justification for conditional use. There is not a problem with proliferation of massage as healing arts modality. Easy access to massage is a great thing for folks who need it. The multi-departmental referrals, I'm not going to have time. All right. Yeah, I guess I'm done. Sure.
Thank you. Next speaker, please. Thank you.
My name is Cheryl Leaf. I'm a CAMTC certified massage therapist. I kept my DPH license for many years. The CAMTC was supposed to override the need for individual licenses per counties and cities. I think today in earlier presentation with photographs, there was shown what a massage parlor looks like. We do not run massage parlors as CAMTC practitioners. We run legitimate massage therapy and healing arts centers. I just want to make that clear. We are not running massage parlors. The language is important, and I think simply from looking at those photographs, law enforcement and those who are against human trafficking would know where to begin their investigations and where to prosecute. Thank you.
My name is Luis Echeverria. I'm an IT technician. I see no one here from the online community or tech community here to talk about this because most of this exists online. You go to Backpage.com, you go to Craigslist or anywhere else. These are where you find these parlors. You talk about making tools with this legislation. The tools are very available. All I see is taxation and hardworking people, more gentrification for San Francisco. I live in Berkeley. I see all these people moving to Oakland, San Francisco because all this is going to do is going to make it for big-time corporation massage places to exist. The small times are going to be kicked out, and a breeding ground for the illegals operations. They operate through phone numbers, through online ads. They hide and sneak. It's very easy to find these places. They're covered. It says massage or the cheap neon. Very easy to find. They don't have open doors. So while I appreciate this legislation, coming from Colombia where human trafficking is a problem, and I'm amazed that in this country we're talking about this. This is amazing. I'm not for human trafficking, but I see this legislation as something from 1995. We're in the tech hub of the world. Google's down the street. Let's use these tools. Where is someone from IT? Backpage.com. Bring them here. Where are they here? They are the most reliable for these issues. You took down Craigslist with erotic services. Well done, but they just floated elsewhere. So I just ask you guys, please work with these, the online community, get some tech people here. If I was a CEO guy, I'd be listened to, but I'm just a hardware technician. I'm just like them. I don't make that big money. Thank you for your time.
Next speaker, please.
Good afternoon. My name is Jake Martin, and I am a tech professional, so I guess there are two of us now. I also grew up in a small business household, so I appreciate the challenges that the massage industry is facing today. I actually just got out of jury duty on Bryant Street about 10 minutes ago. I feel strongly enough about this legislation that I made the effort to be here today. When I first saw coverage last year...
Can you pull the mic to your mouth? We'd love to hear what you're saying.
Sorry about that.
All right.
When I first saw coverage last year of Supervisor Tang's effort to limit the proliferation of illicit business operating in the guise of massage service, I applauded. Those businesses degrade our neighborhoods and stigmatize legitimate practitioners, and I would squarely support action by the board to target illicit establishments to make it difficult for them to operate in San Francisco. But the proposal before the committee today is not that action. The current language was only made available Monday of this week, but I have actually read it carefully. Even with admirable new carve-outs for sole practitioners and existing businesses, this legislation will do far more harm to legitimate business and threaten the livelihoods of valued community members than it will to weed out illicit operators. There's a world of difference between a bodywork clinic and a massage parlor, and this legislation not only fails to distinguish between the two, but indeed clearly proceeds from the assumption that all bodywork clinics are illegitimate until proven otherwise, compounding the insult that illicit parlors already pose to hardworking small business people. I wholeheartedly support more stringent requirements for training, licensing, ongoing education, and professional conduct. But to require each individual bodywork practitioner clinic to devote months of effort and pay thousands of dollars in recurring fees to prove each year to the satisfaction of police, fire, planning, and health that their business is just as legitimate as it was the year before, goes well beyond what can be considered reasonable for businesses of this scale. There's no question that San Francisco would be better off with fewer shady establishments of all sorts, but to reduce the number of adult bookstores by closing all bookstores would serve San Francisco poorly. This new framework.
Thank you. Next speaker, please.
Good afternoon, supervisors. My name is Roberta Guys. I'm the co-chair of public policy for AUW San Francisco. I'm actually speaking, though, for myself today. I do also want to say that AUW nationally has been doing extreme efforts in advocacy and helping to try to eradicate human trafficking. I've been an avid client of massage therapy for decades. I'm almost embarrassed to say for how long. But you get into a very personal relationship with the massage therapist when they're working on you, and you get to know all of their different issues that they're up against. So I really understand the massage therapist's argument against this legislation. However, if we look around the room, how many traffic victims are here today to speak up for themselves? I don't think there's anybody here. And if there was, I'm sure they'd be up here at the podium. So I think this now is for me to say to you that we need to look at this legislation on behalf of the victims. It's possibly not the best or the ultimate legislation, but it's one step in the right direction to helping make it much harder for illegitimate businesses to operate and to function and to do whatever it is that they do. Thank you.
Thank you. Supervisor Tang, are there any other speakers?
Of a person having
Mr. Yip, just want to remind you, Mr. Yip, before you start, Mr. Yip, come back. You're welcome to speak, but you must keep your comments to items 1 or 2.
Public speech, lots of sense. Of a person having true capabilities of having a talent and worldly talent of superior kind will not necessarily guarantee for him having a corresponding social career along his pathway of destiny or mission. Therefore, one should work freely in accordance to one's true and good will of holiness and civilization in terms of missionary goal of target objective with big success. For true way of success is a successful true self, not for all the supporting vision, songs, merchandise, good benefit, position, fame, or those external elements. So please discard all falsify for everything and gain back all true everything for yourself, just for your own good. Okay, well, most men and women, see, even for true husband, wife of true love, it's one's heart. That pointing is one heart, from the heart. Not anything actually physical sex, not even that. Although for both men and women, they enjoy social friendship. Not for some sleazy husband, just wait all day for the sexual desire for the evening. See, I've never had my massage service pay, all my life. All in my life, have not seen any pornographic magazine material, like video, see. Because I'm a person with total cleanliness. So I say, no prostitution, no pornography, not even smoking. So the Sergeant General of Public Health are determined to let you know that pornographic material, prostitution, they're dangerous, harmful, bad for yourself, for personal health, family health, public health. For the police force in control of this massage establishment, also controlling the innocent Chinese people, even Chinatown. To schedule about the police, because the police actually this actively playing the role controlling this massage establishment.
All right. Thank you. Public comment is over. All right.
Thank you. Through the chair.
Yes.
So I just wanted to thank everyone so much for coming out. As many has been mentioned on several occasions, all of the people who came out today who are either massage therapists or businesses, you're the ones who are legitimate and probably will have no issues with some of the things that we're requiring in this legislation. The conditional use process is something that is not unique to the massage industry. It is something that has been used by the planning department to really address issues and to allow for neighborhood input, more transparency of what businesses are coming into which neighborhoods for industries across the board throughout San Francisco in all neighborhoods. So I hear all the comments, the concerns that have been shared, some of which I think are inaccurate and some which are accurate. And I have done my best over the several course of the months to really try to put in as much of your suggestions into this legislation. However, as you know, there is a much larger issue that we're trying to tackle here, and my goal is to give our city departments whatever the tools that they need to really properly enforce the illegitimate businesses. I will share with you that in the Sunset District, I have been working with a business that has a chiropractor, acupuncturist, etc., and there is a business around the corner that is illegitimate, and she has those clients coming into her business, and she would very much like to see that not happen anymore. I have spoken with a constituent who lives in District 4, who lives above a massage parlor, I guess you would say, one that is illegitimate, 2 doorways, one doorway leading to his apartment and one to the business itself, and he has seen people ringing his doorbell, women who are picked up at midnight and 2 a.m., clients who are surprised when they open the door and see him versus a female. And so there are many, many issues that we are trying to address that I think, again, this group here who has come out to testify, really, this does not apply to you. I would say that also there was some comments about using technology and the internet. Absolutely, that has been a tool that our city has been using. For example, in the Sunset District, we have 8 establishments that have received CEMTC exemptions. 6 out of those 8 are actually listed on rubmaps.com, where you can look up reviews for services other than massage. So that's just a snapshot of what is going on here and how we are actually using some of the technology and the internet to be able to better track where the illegitimate businesses are. So I would just say that in summary, I am absolutely happy to work with Supervisor Wiener and some of the suggestions that he has made. I think that at this point, again, my goal is to revert back to what our city has been doing since 2006, actually, for the conditional use permit requirement for massage establishments. And lastly, I would just say that in terms of the fees, those businesses that received a CEMTC exemption were paying about half the fees that those that were permitted through SFDPH. And that is because there was no enforcement arm of things. They set up a permitting system through the state. However, there was no inspections, no inspectors from the state. Everything was relied upon through our own local jurisdictions. And so, although the fee is increasing, those who were receiving a CEMTC exemption actually had it much better than those who were the roughly 100 or so that were established and permitted through DPH. And lastly, after SB 731 was passed at the state level, many jurisdictions, dozens of them, passed moratoriums on new massage establishments. We in San Francisco are not doing that. We are trying to have a much more measured approach, one that we think is much more fair. Again, this is not just for the massage industry. We could have instead said we'd like to issue a moratorium, take more time to think about things and figure out what other regulations we'd like to institute. But we have decided that we will not go that route because we want to be very understanding of many of our legitimate small businesses. So with that said, then, colleagues, I just want to thank you for your time in really trying to understand this issue even prior to this hearing. I do have one technical amendment that is, we can confirm with the city attorney, but from my understanding is non-substantive. On page 2, starting line 14 through 17, just ensuring that the wording will say, for purposes of the planning code only, massage establishment shall include both a massage establishment and a sole practitioner massage establishment, as these terms are defined in section 29.5 of the health code. So again, this was just something our city attorney found that they inadvertently left out, and so we are including this in the legislation. So city attorney, if you could just confirm on the record that it's non-substantive.
Deputy City Attorney John Gibner, that's right. You can make this amendment and pass it on to the full board today without requiring a continuance or a referral back to planning.
Thank you very much. Thank you, colleagues.
Thank you. Supervisor Wiener.
Thank you very much, Madam Chair. And I want to thank everyone on both sides who came out today. And this is one of those issues. It's the worst kind of issue at the board. It's when both sides are right and both sides make really good points. And we know that there is, we have a tangible, very legitimate problem in terms of human trafficking being associated with, and I agree, these are not true massage establishments. These are criminal enterprises that are masquerading as massage establishments. But be that as it may, that's how they're registering. That's how they're setting themselves up, and they are abusing the system. And it is a very, very real problem that's having impacts on people who are just being absolutely victimized. And it's really deplorable that the Bay Area is really one of the epicenters of human trafficking in this country. It's a real stain on the region. At the same time, we have many very legitimate businesses who are not highly capitalized businesses for the most part, a lot of small businesses, and we want to make sure that we are not unduly burdening them. I won't get into the challenges we have with the conditional use process. The conditional use process is one of those processes that makes all the sense in the world from just in terms of how it's defined, but we know that in practice it doesn't always play out the way we want it to play out. I have a few questions for the departments. One is, one of the public commenters mentioned in a situation where you would have, say, 4 co-located solo practitioner massage therapists, that they would have to each pay $2,000 in permit fees and be inspected 16 times, 4 per individual. And I just wanted to get a sense for what would actually be required in that kind of situation.
Hi, Cindy Comerford from the San Francisco Department of Public Health. Each solo massage practitioner would require to get an establishment license. The establishment license, I think it's $599. In addition to the establishment license, the building will need to get a referral from the planning department, so they would be exempt from the CU process. They would have to be inspected by the fire department, and they would also have to be inspected by the building department. Since it's the same location, I believe they can use the same referral and have the same referral fee, but these inspections are necessary for the departments to come in to ensure the safety of the building before the workers and employees are there.
Right, and I'm not disputing the inspections. That's true of really any business that opens up in San Francisco. Okay, thank you for that clarification. A question I guess I have for Ms. Dick-Andrisi. In terms of, and I always forget the name of the program, but I think you or someone else mentioned it before, the special expedited conditional use process that I know exists for certain kinds of businesses, and we've had some restaurants, for example, in Upper Market that have utilized that process, and it's really speeded up or sped up the CU process. What are the parameters of that program in terms of where it applies?
Well, right now, the CB3P, and Diego might be able to also answer some of this in detail, because it is an internal process within the planning department. It is citywide.
But what kinds of businesses does it apply to?
It's designed for businesses that have to go through the conditional use. I think for the small businesses that I can recall, when the CB3 was approved, were massage establishments were one that would not be able to go through. Restaurants that have a full liquor license and a bar would not be able to access the CB3P. Consolidation of space, going beyond the use size limit, and medical cannabis, I think, are the 4 kind of criteria
for not being able to go through.
For not being able to go through the CB3P.
I thought I had a restaurant in my district that I know serves hard liquor that went through the expedited process.
I think I know beer and wine, alcohol, and I know that there was some discussion that if they did serve hard alcohol, as long as they did not have a bar inside of their establishment, but I don't know.
So in terms of the rationale for not allowing massage establishments to utilize the expedited process, could I hear that explanation?
Sure. Diego Sanchez, Planning Department staff. My understanding on the set of businesses that were allowed to participate or not were those that would be less controversial, the ones that we have seen that produce less public outcry or concern. And so that's why you have uses like medical cannabis dispensary or even restaurants that serve hard alcohol as not being ones that are allowed to participate in this expedited process. It's an internal department process.
It's simply it's a policy.
It's a policy.
Okay, and so I would, and I'd be curious to know Supervisor Tang's view on this. I mean, it seems to me that when you have I mean, frankly, we should be erring on the side of inclusion in the expedited conditional use process, because the goal of the conditional use is to be able to go out to the neighborhood, say, what do you think? And then ultimately have a hearing and a decision at the Planning Commission with an open, public, transparent process. And then equally important, to have that permit issued with conditions, saying here are the things you have to do, and if you don't do them, we're going to yank your permit. And the CU gives you a very powerful tool to do that.
That's right.
And so in terms of expediting the process, you achieve everything you need to achieve in terms of public notice and participation and planning commission hearing, and then the ability to revoke or modify the CU if there's a problem. I'm just trying to see if there's a way to deal with the fact that even though, and I'm telling you, I'm going to support this legislation, subject to the trailing legislation that we're going to work on, but I think that the points that are being raised about the conditional use process are legitimate. They're absolutely legitimate, and we have all seen this. And it's one thing, when Starbucks or Safeway has to go through, a 9-month or a 12-month conditional use process. It's painful for them, but they have the resources to be able to absorb it. But when you talk about someone who, especially the way this legislation is drafted now, it's there are a lot of smaller businesses that are going to have to go through the process. Why not give them that expedited review?
I think when this internal policy was being considered and opened up, there were concerns, and there was a decision to err on being a little more cautious with what the universe of businesses that would be allowed to participate in this program would be. And it was concern about trying to minimize the number of businesses that historically have created a lot of community concern, such as medical cannabis, restaurants that serve hard alcohol, those type of formula retail, for example.
And when a business goes into the expedited conditional use process, how does that look different than the traditional conditional use process? I know it means they get to a hearing more quickly, but tell me how is it reviewed differently?
The items on consent is on the consent calendar, which is typically items that are on a consent calendar are those that are more routine matters for the commission, and it's assumed that those can be approved much more rapidly without a lot of deliberation. The case report's also streamlined as well. A normal CU will require a much more in-depth analysis for concentration, for proliferation, for other concerns, depending on the type of use that's being proposed.
But ultimately, there's still neighborhood notice, a neighborhood meeting, a hearing at the Planning Commission. Anyone can have it pulled off of the consent calendar. Any member of the public can pull it off of consent,
That's
right?
correct.
Yeah. And could there be a situation where you allow it to go into the expedited conditional use process, and then if there is an uproar in the community, because we can, when you're talking about, for example, if you have, 3 massage therapists who are a business together, who are going in Noe Valley and renting an office suite somewhere and doing it, it's probably not going to be super controversial. If you see something that's looking like some of these more problem establishments we've seen, it might be much more controversial. And so why not allow a process where you presumptively go into the expedited conditional use process, and then if it seems like it is causing real consternation in the neighborhood, it can then be shifted over to the longer process.
We're more than happy to look into that.
I would appreciate, and I'd like a formal response from the department. And it seems to me that there should be flexibility in saying we're going to start you off in a certain way, and if it turns out that there's some sort of explosion in the community, because there are some issues around it, then we're going to slow it down and make it the more traditional process.
More than happy to look into that.
Okay, and
type of
so
process.
the department will respond formally?
Definitely. we
Okay,
can
I
if you'd
appreciate
like
that. And then this came up a few times in public comment. There are probably a handful of neighborhood commercial districts where this shift from one use category, service, health, to massage establishments means that it'll now be banned in that NCD?
There's about 7 out of the roughly 40.
Now, the existing ones will be grandfathered in?
Assuming they can take advantage of the proposed legitimization program that's in the proposed ordinance, yes.
Right, but they'll be able to, they won't be, if they're able to legitimize, then they will not be banned?
That's correct.
Okay, but then new ones coming in they'll be banned in those areas?
Right, and we're assuming that's because the community, the supervisors that have those districts where it's not allowed have done a community process, and that's what's been decided by that community that as to the scope or the breadth of uses they want to see in their community and the ones that they don't. And
right, except that for a number of years now, the planning code classified them as health, or service, health, medical. So they were allowed.
Well, that's because the state ordinance, I think from 2008, required that local jurisdictions not consider massage establishments any different than a medical professional service like a chiropractor.
Okay, so that's helpful. So basically, before the state stepped in and preempted everything locally, these 7 neighborhood commercial districts banned massage establishments, and then the state told us, no, you can't treat them differently from other health-related services.
Right.
And so we complied with that, and now this would take us back to when we had local control before?
That's correct.
Okay, and do you happen to have a list of what those NCDs are?
If you give me a minute, I'll...
Okay, thank you.
Okay, so the NCs that do not allow, that prohibit massage currently are NC1, Outer Clement, Sacramento in most cases, Union, West Portal, Pacific, and NCT1.
Okay, and what is NC1?
NC1 is, I believe the name is a small cluster commercial district. It's perhaps the least intense of all the NCs.
And NC, what was the last one you said?
NCT1.
Which is what?
Similar to that, except for it incorporates the new form-based code with respect to parking maximums and residential density.
Is there a map that shows where they're banned?
We can get that. I don't have one.
Okay,
though.
could you provide that to me?
Sure.
Or maybe to the whole committee?
Definitely.
That'd be interesting to see. Okay, thank you very much for sitting on the hot seat for a little while. Okay, so again, thank you to the departments, and those answers were all very helpful. And so we'll be, from the planning department, we'll get a response around the potential of including massage establishments in the expedited conditional use, with the possibility of shifting them over to the longer CU if it seems like it's controversial in the neighborhood, or there are other circumstances showing that it could be a problem. And then we'll be working on, what I'd like to do is duplicate the file for both items 1 and 2, so that we'll send the items forward to the full board, but keep a copy or duplicated copy of the file in committee, continue to the call of the chair, and then we will be considering trailing legislation to deal with the issue of when an existing massage establishment needs to move and whether they would have to get a conditional use for the new location. The issue of massage therapists who are accessory to whether a chiropractor, acupuncturist, and whether that should reflect the status of what the legislation currently allows, i.e. up to 4 independent massage therapists who are co-located together. Because again, right now you could be 4 co-located massage therapists, you do not need a CU, but if you're a massage therapist co-locating with a chiropractor, you do need a CU, and that seems a little bit odd. And I think those would be the two issues we'll be looking at. We will work closely with the departments and with Supervisor Tang's office on those possible amendments, and so I would that's how I would intend to proceed. I also, one amendment that we can make today, which I'd like to just put out there, is to change the title from massage establishment to, and this would be section 102 of the planning code, to change it to service, health massage, to make clear that we're not somehow saying that this is no longer a health related field, and that amendment would then have to be throughout the code. And so I understand from the city attorney we could make that amendment today. Again, that's not a substantive change to anything, but I think in terms of the concern that we're somehow now saying you were a health-related field, now you're not. So wanted to put that out for the city attorney.
Deputy City Attorney John Givner. Yes, you can make that amendment today, and it wouldn't require a referral back to the Planning Commission, and it wouldn't require a continuance. It would require changes throughout the planning code. The term massage establishment appears in dozens, probably more than 100 places in different sections of the code. What I'd recommend, if the committee is amenable to it, is changing the definition in section 102 so it says massage establishment or service health massage means the following, so that we have basically two alternative definitions, and then anywhere in the code that we could use either definition, either term to mean the same thing. That would have the same effect. I don't know if it would accomplish exactly what you're hoping to accomplish, Supervisor, but it would get the new term in there, and going forward as we make changes to the planning code, we could use that term.
Okay, thank you. Madam Chair, I'll defer to colleagues for further comments.
Thank you. I just had a couple comments. First, I wanted just to thank Supervisor Tang for bringing these two items forward to us. Also acknowledge the work that Deanna Kizon has done, but also want to give a hearty thank you to the community stakeholders that came out. Not only has this issue been very informative, but it's also cut very close to home. I particularly want to thank the folks who own their business and who are working in the industry coming out and sharing with us their experiences and more or less their fears about what a CU will do to their business. I want to just also acknowledge that I heard very clearly that there was a distinction of language between massage parlor and the others out there. And I want to recognize first that I believe that this is the first time this segment of the industry has been organized or is organizing themselves around a particular issue, and I want to applaud you for that. That's very important. One of the things I heard also in public comment is that you would like to change the distinction, I think it's state legislation, or make the distinction in state legislation, distinguishing your business from massage parlors. I agree. I think that is very important, and that's a matter of educating the general public. I, too, have heard very compelling arguments from both sides and can appreciate the trailing legislation that Supervisor Wiener was proposing. I think that is something that we need to do to begin to clean up this legislation. I understand the express intent of what Supervisor Tang is trying to accomplish here with this legislation, but we do not want to create something that is overburdensome or onerous on small businesses. And like Supervisor Wiener said, there are larger establishments that will be able to come in and shoulder the financial burden. Establishments like, I think of just Massage Envy just off the top of my head, that can come in from a corporate perspective and be able to pay these additional fees. And so I am sensitive to making sure that the CU is not a barrier of entry into the industry, and also not a barrier that would prohibit a business from expanding. So I just wanted to echo that we've heard that, we've received that, and I'll be working with Supervisor Wiener on that trailing legislation, partnering with the planning department to figure out a way that we can begin to relax that. I I do believe that we do have a serious problem with exploitation of women and girls in San Francisco, and many of you recognize that. And it is unfortunate. It's okay, no problem. We're family friendly here. It's unfortunate that the exploitation commonly occurs in the massage establishment, and I understand that some of the concerns that the massage practitioners have with this new legislation, with the new regulations, but please understand that it's our job as policymakers to begin to strike a balance. We want to protect your interests as well as protect protect and defend the women that have been human trafficked here in our city. We want to we as policymakers want to make sure that we balance your interests with the policy goals of working to eradicate the massage establishments that victimizes women. And that is the one thing that I heard consistently when I was listening to public comment. And you guys are very familiar with the expression, one bad apple can ruin the bunch. And it's unfortunate that seems to be what's happening with this particular industry. So I am committed to ensuring that we don't let those bad actors ruin the good work that many of you are doing. Quite frankly, I think in many ways, saving lives, massaging people, relaxing tension. It's extremely stressful here in San Francisco. Whoever wants to massage Supervisor Tang after this, I will pay for it. This woman has been working incredibly hard and deserves a little release and some tension. So please, we have to take care of each other. And let's see, I think, Supervisor Wiener, is there anything else that you wanted to say on this item? If not, I'm going to go to Supervisor Tang.
No.
Okay, thank you. Supervisor Tang.
Thank you. Thank you, colleagues, for all of your very thoughtful comments. I think that, again, the CU process is something that we're all grappling with. And in fact, recently I called a hearing to really do a deep dive into our city's permitting process, especially for the restaurant industry, where it can be very complicated and involve many, many different departments. We're trying to take what we learned from that process and apply it across the board to all of our small businesses. So it's certainly a topic that I've been interested for many, many, many years. And so a lot of it is not in the legislation. All of that work that we're going to be doing on the implementation side is very important to making sure that this, whoever's going through CU can go through it efficiently from whether it's the client's end or from the planning department's end and all the various departments. So in terms of the expedited permitting process, that's something that our office was not in particular involved in that conversation with the planning department when they decided which industries would go through it or not. However, again, like I said, we are going to be working with all the departments, sitting down with them, making sure that everyone's on the same page as to how it is that this work will be carried out. And so I would actually, again, I agreed to work with Supervisor Wiener on trailing legislation on the amendment. So I would like to suggest to the committee if we could forward on this legislation, and if Supervisor Wiener has separate legislation, to consider that separately.
So is that a motion?
I think Supervisor Wiener made a motion
first. Do you want to speak
so.
to first, and then we'll entertain a motion?
Well, I believe that's a motion to forward this to the full board. Before, what I want to do is, first of all, to request that we duplicate items 1 and 2, that we duplicate the files.
Yes.
And that we continue the duplicated files for number 1 and 2 to the call of the chair. And then with respect to the various amendments I described, we will work on those in a collaborative way, and ultimately any amended legislation would have to go back to the Planning Commission and then come back to committee here.
Okay, to the folks at home, let me just translate that for you about what just happened. I can see the puzzled looks on your face. So what we have done is we've duplicated the file, so that means half the file legislation will, if it comes out of committee, will move forward. The other half will go back to, is it the Planning Commission? What did you say? Were you sending it back to?
So for the members of the public, what we're doing is, because there are amendments that I would like that we'll work on that we can't do today because it, for various reasons, has to go back to the Planning Commission to comment on them. We're going to duplicate the file. We're going to keep that version of the file in committee so that we can make the amendments going forward and then go back to the Planning Commission and go through that whole process rather than have to reintroduce new legislation, which is a more cumbersome process. But then the original version, Supervisor Tang will be able to forward that to the full board. So we'll have a two tracks for the legislation.
Okay, so that motion was made by Supervisor.
The duplication, I'm requesting that we duplicate, which I think that's automatic, if I'm not mistaken.
There's no second needed for that motion?
There's no motion. Any
Excellent.
supervisor can duplicate the
All right, thank you very much. And Supervisor Tang?
Thank you. Before we duplicate the file, though, however, should we formally accept the amendments that I made?
Yes.
All right, so the amendments, a motion made to accept the amendments by Supervisor Tang has been accepted and seconded by Supervisor Wiener and accepted unanimously by this committee. That motion passes.
Right. So then I request to duplicate the files for 1 and 2 and to continue the duplicated files to the call of the chair. That would be my motion.
And through the chair, just to clarify, and then other amendments on top of that, you're planning to do separate legislation for? Is that correct?
No, so the duplicated file that we're keeping in committee, any amendments we would do as substitute legislation for the file that's being kept in committee. And then we'd have to refer that to the Planning Commission at that time. And so this would not preclude, through the chair, Supervisor Tang, your legislation from moving forward.
City Attorney.
Sure. Just this is probably getting super technical, but just a couple suggestions. A substitute can only be introduced by Supervisor Tang, even on the duplicate, unless the sponsorship changes. So just so you all know that, of course, at any point, any supervisor can introduce a new piece of legislation that would be sent to this committee on the same topic. The other piece is that once a committee amends an ordinance, a substitute cannot be introduced. So what I'd suggest is that the motion to amend that Supervisor Tang made, that apply only to the version that you're sending out. Leave the original duplicated file in its original form, and then if Supervisor Tang chooses, she can introduce a substitute in that one later.
That's fine with me, and then anything that we do in the future, we would just incorporate the technical amendment that Supervisor Tang made.
Supervisor Tang, is there any last words?
Oh, no, that's fine. I mean, if that's the city attorney's recommendation. So the one that I read, the amendment I read into the record, we should not adopt that today.
You should adopt that for the version that you're sending out to the full board today, but not for the duplicated version that you're leaving in committee. Here's what I'd like to recommend, Madam Chair, if we could then rescind the vote where we amended the whole thing, and then I will, once we rescind that, I will first make a motion or request duplication of the file, and then move to continue the duplicated file to the call of the chair, and then we can proceed with the original version.
Okay. All right. All right, may I have a motion to rescind the vote? All right, motion made by Supervisor Wiener, seconded by Supervisor Tang. Motion passes unanimously. This is to rescind the vote. Okay, is there a motion that I can entertain on the floor? Supervisor Wiener?
Yes, so I'm requesting to duplicate the files for both number 1 and number 2, and then I move to continue the duplicated files to the call of the chair.
Okay. That does, correct me if I'm wrong, but that does not need a vote.
It does. The motion does.
The motion to continue to the call of the chair does require a vote.
Okay, so a motion to continue made by Supervisor Wiener, seconded by Supervisor Tang. This motion passes unanimously by this body. Thank you very much. Okay. Now.
And then Supervisor Tang's amendment we can make to the...
Supervisor Tang, could you
restate
your motion?
So
your amendment?
I previously stated amendments, a technical amendment, and I'd like to make a motion then to amend that into the original piece of legislation that will be traveling to the full board.
All right, can we accept this amendment unanimously? All right, accepted unanimously. Thank you very much. Okay, ladies and gentlemen, that was democracy in action.
We have to put
We're in the motion to recommend.
We have to take this out. We have to now put it out of committee to the full board with a positive recommendation.
So through the chair, if I could, yes, make that motion then for the original version to send it to the full board with a positive recommendation for items 1 and 2.
All right, this motion passes unanimously. All right, thank you very much. Madam Clerk, could you please call item number 3?
Item number 3 is a resolution imposing interim zoning controls for medical cannabis dispensaries in Irving, Judah, Noriega, and Terraville neighborhood commercial districts.
Okay, thank you. Ladies and gentlemen, Supervisor Tang is also the author of this particular item. Supervisor Tang will make a short presentation.
Thank you. So item 3 before us is really seeking to correct some changes that were made recently to the planning code and had some unintended consequences on some previous legislation. Previously, in the 4 neighborhood commercial districts in District 4, Irving, Judah, Noriega, and Taraval NCDs, there was a requirement in the planning code that any inactive ground floor uses must go through a conditional use permitting process. Recently, the Board of Supervisors adopted a roughly 500-page code cleanup in which there were new requirements set for medical cannabis dispensaries, one of which is requiring transparency on the ground floor. That removed, with that change, it removed the medical cannabis dispensaries from the definition of inactive uses. It is now an active use, thereby changing legislation that was passed by a former supervisor and negated that legislation. So today we're really just seeking to correct that, given the recent code cleanup legislation, to require that it put in place interim zoning controls that would require a conditional use authorization for medical cannabis dispensaries in the Irving, Judah, Noriega, and Taraval neighborhood commercial districts. Happy to answer any questions, and I know planning staff is available here as well.
Okay, seeing no questions with the colleagues. Planning, is there any presentation? Nothing? Okay, no problem. Let's go ahead and go take public comment on this item. Public comment on item number 3 is open. Please, if you have a comment, please comment up. Thank you.
Hi, my name is Paul Hansberry. Good afternoon.
Good afternoon.
The code was very clear that it was permitted with a discretionary review. It seems to me, in my opinion, it was a stretch that it would require a conditional use because it wasn't listed on a certain table, even though it did qualify as an active use. There was a discretionary review hearing scheduled for March 12th. 10 days after that was when this went into effect. It was already a clarification. I would beg to differ that it was not an inadvertent thing, but it was, in fact, a deliberate clarification of the use as an institutional healthcare use, which is an active use and defined on the table 145.4. I know that there's a lot of controversy in the Sunset District regarding, and people are very passionate and vocal about it. But I think that the patients of the Sunset deserve it. The interim controls are to be used for when there's an urgent need for this to happen. I think there's more of an urgent need for the cannabis dispensary to open for the people, the patients in the Sunset. There are a number of establishments that most of the people in the Sunset have never been in. For instance, say a synagogue, but there are many there. So I would strongly advise that we stay with the way that the code is written for the rest of the city and not make the exception for the more rigorous conditional use. Thank you very much.
Thank you very much. Are there any members of the public that would like to speak on item number 3? Seeing none, public comment is closed. Thank you. Supervisor Tang, is there anything else?
Thank you. First of all, I'll just say I don't appreciate any insinuation of any suggested actions that were taken. I stand by what I stated. We're trying to correct something that was inadvertently changed through previous legislation. So with that, then I'd like to just recommend to our committee members if we can forward out item 3 with a positive recommendation to the full board.
Supervisor Tang has made a motion, and it's seconded by Supervisor...
I'm sorry. It says a committee report? It says a committee report.
Oh, yes. I apologize. I amend that motion to say that it would be sent forward with a positive recommendation as a committee report to the board on May 5th, 2015.
All right. And before we take that vote, Supervisor Wiener.
Thank you, Madam Chair. I just want to also just be clear that the conditional use requirement previously existed. It was inadvertently wiped away, and I will take full responsibility for that. I sponsored on behalf of the Planning Department a broad code cleanup that this board passed a month or two ago. Code cleanups are always complicated. It was, I think, a 500-page ordinance with an enormous number of changes. And when we do code cleanups, it's actually very rare that you don't at some point inadvertently change something that you didn't intend to change because different parts of the code interact with each other in different ways. And this actually happened a few years ago when I authored a broad restaurant permitting code consolidation and cleanup, and it inadvertently wiped away a very specific control on Union Street, and we went back afterwards with Supervisor Farrell and corrected that by restoring that control, which we had not intended to wipe away. So there we go. So for this code cleanup, it was not our intent to impact existing controls on this issue in the sunset, and so whatever one's view on whether there should be a conditional use, I think it's appropriate to restore the existing control.
Thank you, Supervisor Wiener. Supervisor Tang has made a motion to refer this item to the full board as a committee report for consideration on May 5th, 2015, seconded by Supervisor Wiener, unanimously passed by this body. Madam Clerk, could you please call item number 4?
Item number 4 is a hearing to review housing resources programs, an option for retention of rent-controlled housing.
Thank you. Thank you. So, colleagues, this item is sponsored by Supervisor Christensen. I've received a request from her office that we continue this item, as many of the stakeholders who were intending to present on this hearing are at the Housing Working Group meeting. But before we entertain a motion to continue, are there any members of the public that would like to speak on item 4? Please come forward.
Good afternoon. I'm Marla Knight, and I'm from the North Beach Tenants Committee. I'm happy to participate in this hearing, though it's almost a non-hearing, isn't it? Anyway, in 2013, I, along with 21 other neighbors, were evicted under the Ellis Act, and this is just on one block on Lombard Street. At that time, there was no place to go, and there's still no place to go. I traveled to Petaluma and managed to get on a waiting list for senior housing in Petaluma, and that was 2 years ago, and I'm still on the list. Ellis Acts are once again up in North Beach and the rest of the city after a short hiatus. In addition, we're losing whole units in North Beach, which are being illegally rented as short-term rentals. I would like to see, one, that teeth be put in the enforcement of the short-term rental law, because these units are being taken out of the housing stock and being illegally rented. And if there's no enforcement, and that means having data from Airbnb and the other platforms, this is going to continue to happen. I would especially like to see the small sites acquisitions program expanded. I think it's much better to have housing that is here and keep it, retain it much faster, and people want to stay in their own homes. I'd also like to see real landlords, not speculators, rewarded in some way for not evicting people. I'm a retired City College teacher, a volunteer tutor at Telegraph Hill Neighborhood Center, and fourth-generation San Franciscan, and I'd like to see my community stay intact.
Thank you very much. Thank you. Are there any other members that would like to speak on the... I'm sorry, you've already spoken. I'm sorry, you've spoken already. We have to continue.
I'm sorry, I thought you were still...
No.
Yes, good afternoon, supervisors. Just to echo what the previous speaker said, it's incumbent upon the city to really take this issue seriously and implement measures that will retain and will keep people housed. Seniors, and particularly seniors with disabilities, people with disabilities are particularly vulnerable. We're seeing a spike in low-fault to no-fault evictions right now, where tenants are being duped out of their long-term units, rent-controlled units and otherwise, but many who are being duped out of the long-term rentals for lack of knowledge. So resources into educating folks about what their rights are, that to keep them out of harm's way so that they don't they don't suffer eviction and undue eviction. And also with the short-term rentals, from what I understand, there's something like 5,000 of these unregulated short-term rentals that are going on in San Francisco, many of which fall under the rent control stock. And, that's of grave importance to our organization. We're on a mission to really educate folks and to get people aware of what their rights are. But the cannibalization of the rent control stock is something that's quite troubling and something that we need to reverse. And again, our organization's position is that we are in favor of the concept of aging in place, that folks should be able to age in their homes and not be put in rest homes or care facilities. And that's it. Thank you.
Thank you very much. Seeing that there are no other members of the public that'd like to comment on this item number 4, public comment is closed. Colleagues, may I have a motion to continue this item to the call of the chair?
So moved.
Thank you. Motion made by Supervisor Tang, seconded by Supervisor Wiener. This motion unanimously passes. Madam Clerk, is there any other business before this body?
There's no further business.
Thank you. This meeting is adjourned.